whenever we are directed to do it, is doing the staffing analysis in accordance with whatever direction we get from the legislature. So that's the end of our presentation. Happy to try and take any questions.
Thank you, George. Thank you, Ewing. Looking around the room to see if there are questions here or commentary. I would imagine there might be plenty of both. I'm looking at the screens as well. Certainly, it was interesting to me to read those 25 pages and see the time and attention that the LAO gave to what I perceive to be still in an evolving office under your new leadership, George. And so I don't know how that affects what point in time they're looking at and whether you and your leadership see things moving in perhaps a different direction than they may have seen at that point in time. Just a general thought.
Yeah, I mean, I don't, I think, some of the things, first you should know that we had extensive discussions with the LAO and the court before they prepared their report. So we went over a number of these issues with them, talked them through. I think we disagree with some of the things they say, but agree with many of the things they say, in part because of that conversation. In terms of where the office is going, I think there are some changes we're contemplating that accord with things that the LAO suggested. So, for example, we are considering whether some of our cases are more efficiently handled horizontally as opposed to vertically. And as you know, we do have in place a pilot program to handle client trust account cases in a specialized team. We should have the results of that. The pilot program is still ongoing, so we should have data from that after the pilot program has completed in either late February or early March, which I think will give us a handle on whether we want to make that type of specialized team, which is one thing that the LAO commented on, whether we want to make that specialized team permanent. So I think some of the changes, in fact, mesh with some of the LAO suggestions. In terms of the timing, I would hope that most of the changes we're going to make will be in effect in hopefully the first 2 quarters of this year, which would then put us in a position to have them in place and potentially do the staffing analysis as they suggest, potentially in 2024. So that's kind of a tentative idea.
Thank you for that. Trustee Tony.
Thank you, Chair Duran. I was pretty impressed by this report by the Legislative Analyst's Office. I've had experience with their office through my other work, and I've always found them to be very thorough, very thoughtful, very objective. They really pride themselves at trying to be a little bit above the fray and be consummate professionals when it comes to analyzing issues that they're actually look at. One of the things that I want to point out in particular, and I'm stating my point of view for now, and I realize this isn't an action item, but just in terms of the conversation, it's very easy for a body like ours to, be a little leery about additional oversight, about wanting to feel like, well, we're trustees, we should be given some leeway and that kind of stuff. And so one of the interesting proposals I want to focus on is the having the State Bar budget go through the budgetary process and be approved by the legislature. And that's something that I kind of like that idea. I'll just be honest with you. I'm very favorably disposed to that, and I'll tell you why. With a lot of my work at the Utility Reform Network, through that, I'm aware that the California Public Utilities Commission has their budget approved through the budgetary process. And they're in a similar situation. They're regulators. They're not funded by the state. They're not funded by the state budget. They much like the state bar, are funded almost exclusively through regulatory fees, okay? And so on one hand, you could look at that and say, well, why should the state legislature approve a budget that they're not contributing to? And the answer to that is a budget is a monetary reflection, a financial reflection of the work that a body is expected to do, that a state agency is expected to do. And what that does is, I think that in the case of the California Public Utilities Commission, it allows the legislature to create a stronger link between the activities and the mandates that they expect the body to carry out and the budget. I'm going to give you a specific example. So because the, and you'll have to forgive me if I get the wrong committee that does this, but one of the, when there is a bill that, a proposal, we want the California Public Utilities Commission to do X, Y, and Z. That bill has to go to a committee, and I don't remember which one, someone can help me out, that basically does an analysis of how much it'll cost. How many more FTEs are required to carry this out? What is the budget? So that every bill that's passed is passed with a component of it that actually has very specific. This requires 5 FTEs, and this is the fiscal cost of it. But in other words, the fiscal cost of everything that the legislature wants the PUC to do is documented as part of the budgetary process. And I think that's something that's lacking in this particular, with the state bar, that there's a disconnect. And so when we complain about, well, it seems like we keep being asked to do stuff in the state legislature, it's because they're not looking at our budget. It's because it's not going through all the budget subcommittee processes before it gets to the budget committee, before it gets to the floors, the bodies themselves. So I just want to encourage my colleagues to think about this and to, we don't have to decide right now, but to consider the advantages of enthusiastically embracing a proposal that the state bar budget approval, development go through the legislature. Just wanted to share that perspective.
Thank you, Mark. Vice Chair Stallings, did I see your hand go up?
Yes, thank you. Thank you, George, for that report back and for all the work that's gone into working with the LAO on this important topic. I wanted to follow up on the LAO's recommendation that ENECs be eliminated. And we've had the ad hoc group on the discipline system look at ENECs. We've received a lot of comment from the defense bar. We've received input from OCTC, and I just wanted to ask, in relation to the LAO's overarching concerns about case processing times, how a significant amount of time, I think the average was 79 days, was spent on either one ENEC or multiple ENECs prior to the case actually being charged in state bar court and the case being litigated. What are your thoughts on eliminating the ENEC, and if that were to happen, would that have a corresponding impact on OCTC workload, or would there be a way to kind of ease into phasing out ENECs if that did actually happen?
So to be fair to the LAO, they didn't suggest that. They raised that as a question for consideration by the legislature. Our experts in the SB 211 process did in fact suggest that. They suggested eliminating the ENEC or moving it to post-charging. I think their concern was motivated by the fact, well, I'll give you my personal views. It's very, very different from any criminal process. You know, as a criminal prosecutor, the judge, you know, prosecutors are not required to go to judges before they make an election to file charges. That doesn't necessarily mean that there aren't pre-filing settlement discussions, but those typically occur between the parties, not mandated before a judge. So my personal view is that it might make sense to do away with the ENEC and to basically move to a situation more akin to the criminal process where in fact there's the opportunity, if both parties want, to enlist a state bar court judge to assist in settlement discussions pre-filing, but that it's not mandated. You know, I think that would have an impact in terms of, you know, there are some cases we have where it's absolutely clear that, you know, based on the evidence, we believe charges are warranted and we're going to proceed. The other side doesn't, and we're not going to reach an agreement before the charges are filed. And in those cases, you know, I'm not sure that the ENEC serves any purpose. Now, are there some cases where an ENEC does serve a purpose? Absolutely. You know, there are cases we have where we'll go to an ENEC where we have a particular view of the evidence. We have the opportunity, and the state bar court weighs in, and we'll then change how we view the evidence. But I think a voluntary system where that was voluntary between the parties could serve the same purposes, and effectively, you know, if the data is correct, eliminate some time that is currently mandated in all cases before charging. I should also note that, you know, it's not always the situation where the other side requests an ENEC either. We on occasion will send out a notice saying, do you want an ENEC? And they'll say no, and then we'll just proceed. So there is a range of cases, but that's my personal view.
Thank you.
I was just going to ask, George, and even though the question is posed to the legislature, the board on its own could modify the ENEC process. Is that correct?
Yes, the NEC process is something that's in the rules of procedure. I'm not aware of a statute that requires it.
Right. And then, you know, for my personal, one of my takeaways from the LAO report is just the notion that we should be looking at the entirety of the case processing timeline, including the period during which the case is in state bar court. I think that's a point well made, and I think that that's something that we should consider going forward. And if you did that, perhaps it becomes a little bit less relevant, this issue of the ENEC and its timing, because you're looking at the entirety of the case processing time frame.
And I think, Leah, to that point, you know, I know that we worked really closely with State Bar Court and some of these issues going forward, and so I think that's probably my message at this point, is to work with State Bar Court to look at those issues and get their input before any action is taken.
Good points all. Any other questions or comments on the LAO report or Mr. Cardona and Ms. Jiang's presentation? Okay, no action again on this item, so we'll move on to, so I'm going to do a little bit of agenda management here. I'm showing 142. I know that we have time certain for items 703, I think maybe, to start at 2:30. Next in order is the discussion on the ad hoc commission on the discipline systems recommendations and ideally approval. Something tells me that's going to be a meaty discussion, probably at least 45 minutes, maybe an hour. Would it make sense to skip over that and go straight to the case processing metrics? I don't know that we lost Ewing, but I don't know if Ms. Chavez is teed up yet or not.
I'm sure she is, because she's prepared to report on the ad hoc commission.
Oh, correct. That's right. If there's no objection, let me just switch those two items so that we'll start with 60-4, the case processing metrics. And then maybe we'll go into 2201 after that. Ms. Chavez, I'm assuming and hoping that you're making your way into our screens. There you are. Good afternoon. Welcome. Happy New Year. And will it be you or Ms. Yang who is starting?
Ewing's going to be leading our presentation.
Yep.
There she comes.
Hi,
Ewing is great.
there's no presentation, so we have this agenda item. Hopefully if you do not have a chance to review it, it's a short one, you can review it right now. So the agenda item is about case processing metrics. The first thing I want to point out is that the name has been changed to case processing versus discipline metrics for two reasons. One is more areas, functional areas in the state bar fall under the broad header of discipline. For example, probation. And if you see the attachment, we are not including probation into the case processing metrics. Another more important reason, in my opinion, is that we really want to focus on the complaint case processing aspect of work. It's more of public concern. It's tied up with our most recent SB 211 standards development work. So that's one change we have made. The process of developing this year's metrics, when you read the agenda item, you can see that we have been doing this. This is a continuous effort. We have made, I would say, significant modifications and updates based on the changes and the new information sources. Lisa and I sat down with the division and the office leaders. We reviewed two things. One is their previous metrics. The other one is the strategic operational plans and goals in that particular division or office. So we want to bring all the thoughts about how we address our strategic plan, what are the most important things for the division or the office, what measures, we always talk about measure what matters. Measure what matters. So the attachment is the final but tentative metrics. We do not ask the board to approve the metrics because, as we said, the SB 211 standards are still pending. Also, ad hoc commission work is not finalized. So we need to bring into all those considerations to the final metrics. But we do want to hear your feedback or your questions so we can add your suggestions to the final metrics. Lisa, you have anything to add?
No, I don't. Thank you.
These are the metrics that we will begin using for board reports. Also, ultimately, the dashboards that are prepared for the Chief Trial Counsel. And now today, for the first time on your agenda, you see one for the Special Deputy Trial Counsel. They would be amended as needed to reflect the metrics. So that's how these will be used for our reporting to the board, our reporting to others outside of the annual discipline report.
Thank you all for the quick overview. Any questions or comments from the board on the chart, on the presentation? Mr. Tony.
I really appreciate seeing this. My only comment and just a suggestion is if there's a way to, a list of 19 metrics is a lot of metrics, and it's difficult to have all that in my head when I am assessing something. So there are two things that could help. One is to categorize the metrics into different buckets. I don't know exactly how to do that, but just take a look and see if there are groupings that they can be put into. That's just one idea. Sometimes groupings can lead to indexes, right, when it comes to metrics. That's one. And the other is, are all 19 metrics equally important? Are there some metrics that are kind of like the most important ones? So those are just thoughts. I know it'll help me understand them, and it may help other people. So that's my only comments. Just, I'd like the staff to just think about that a little bit.
Thank you, Trustee Tony. Vice Chair Stallings.
All right, thank you. And just to echo Mr. Tony's comments, I was thinking about how to best break up these 19 areas, and some really track with the check and balance on our discipline system, tracking the Walker petitions, tracking the complaint review unit, and these are all, I think, important metrics for our stakeholders to view, because then they can trust that the work product that we're putting out has been checked, and it's important as as a body to look at those metrics and to perform our oversight functions as well. So I would maybe have one grouping as oversight metrics. I think there's another bucket that could be listed as state bar court metrics, and then
Can I quickly address the grouping question here?
Sure, go ahead.
Okay, so I think if I have a few minutes, I can quickly kind of walk the board through our sort of not so obvious logic or grouping here. So first of all, it's grouped by responsible office. So OCTC, you can see they have 8 metrics, SDTC, Special Deputy Trial Counsel, 3 metrics. So by office here, so that's number 1. Then for OCTC, 8 metrics. The first 1, 2, 3, they focus on speed, case processing speed. So we want, fasten our case processing time. Then number 4 and 5, they address some of the new emerging issues in case processing area. One is, for example, track percent of discipline cases result in non-public discipline. So that's a new metric, and we only propose track because we never tracked it before. The other one is the track number of attorneys who have 15 plus prior complaints and discipline outcomes for those attorneys. So those are the 2 newly added metrics based on the recent audit report and public concern. Then 6, 7, 8 as explained. I don't remember the trustee's name. That this 3 is about quality. So when we are under a lot of pressure to process cases quickly, whether they are processed in a reasonable fashion and whether they are processed with the quality they deserve. So 6, 7, 8 is about case processing quality. So 9, 10, 11 SDTC at this point, because they are this is our very first time to even propose metrics for SDTC. So they focused a lot on their time because as you will see from Stacey's presentation, 2201 cases, we have some backlog, long cases. So we focused on the case processing time for SDTC. Then for State Bar Court, I do want to add some notes here that are from the State Bar Court. First of all the new metrics are still pending presiding judge's approval. So they have approval process. Then the number 12 is related with our discussion about the ENEC. So we can continue to track and monitor the time that spent in the ENEC process. Then number 13, time, again about time. Number 14 actually is an updated metric that the State Bar Court used to track. Then number 15, 16 is about complaint review units case, more about the case processing quality. Then number 17, 18, 19, it's a State Bar system-wide metric. System-wide means that one divisional office may not be responsible for the whole for tracking the whole metric because it involves multiple divisions or office efforts. So that includes percent of respondents that retain representation, track recidivism rates, and the track satisfaction rate of complaining witnesses. Would that help a little?
Yep, I think it would. And you touched on my last bucket, or one of the final buckets, and that was some of these issues that we've taken up in response to the FARCA study and then the Professor Robertson recommendations. It would be certainly helpful to be able to continue to communicate with our stakeholders and with the broader public about how the steps that we've taken to ensure equity in our system are really being rolled out, and the impact that it's having on the cases going through our discipline system. So I think having that, those metrics would be especially important when these issues keep getting brought up. So I'm all for continuing to study and then report out on hopefully the good things that we're doing in the discipline system to reduce inequity.
Right.
Here on that. Any other questions? Mr. Tony?
I just wanted to thank you, Wynn, for going through the categories that are already here. You made it very clear. I like them. And you've already done the work of categorizing them. And thanks for pointing it out. And my only thing is that when you present it, that you just go ahead and present it in the categories that you said, because I think you got it already. So thank you.
It strikes me also, as listening to the conversation here, that in addition to the purposes of this update on matrices, metrics as a whole, what's wrong with me today? This chart is a very quick and easy way to see the full breadth of the many different arms of the state bar. Right? There are significant resources, people-wise, brain-wise, money-wise, facility-wise, going into all the work that happens at this agency, and this is a really nice way to see it represented in just a few pages. And so I would commend it to folks who sometimes have a hard time getting their hands around or their arms around the various things that happen at this agency, just to take a glance at this, and it's a pretty good cheat sheet. Okay, if there are no further questions on the metrics, let's move on to another metrics item, which is the Rule 2201 metrics. These 2201 Administrator Stacy Laguna should be joining us. Good afternoon and welcome.
Hi, good afternoon, everyone.
We can hear you. Go for it.
Okay, great. Today I'll be presenting on the Rule 2201 program's performance metrics. And I have, this will look familiar to you. It's very similar to the performance metric dashboard that the Chief Trial Counsel uses. Can everyone see it?
Yes.
Yes.
Okay, great. So this is the first time I'm able to present this to you. It's been in the works for several months. And this is an interactive dashboard that's available to the public. What I have today is in PowerPoint form. So some of the interactive features will not be available today, but you can certainly check them out on the public dashboard. So here, like I mentioned, this should be a familiar interface for you based on George's presentations in the past. Before we get started talking about the specific metrics, what I would like to point out is the Rule 2201 program will actually have two different dashboards. And the reason is this. We are able to measure our case processing standards or our case processing metrics based on two different starting points. One is true case age, which is important to know because that is how backlog is measured under the statute. So that's important for reporting to the legislature. Our metrics based on true case age. The other metric for consideration, or the other starting point for consideration, is based on when our program actually gets the case. So that's more useful for me in terms of management to know how quickly the deputies are processing after referral. So what I have for you today is based on true case age, and I think in future meetings I'll be able to show both of the dashboards. But for today, based on true case age, consistent with the backlog standard that you're used to hearing about. So the first metric here is caseload clearance rate. You may recall from George's presentations, this refers to incoming cases versus outgoing cases. So if you have a rate of 100, it means you're reaching a disposition in a case for every case that's coming in. Here we've got a rate of 80%, and this is for the last quarter of 2022, so October 1st through the end of last year. This is a decrease in clearance rate from the previous quarter, but what I do want to highlight is the previous quarter's number, which shows that we had a great case clearance rate for the prior quarter. There it was 241. So we were reaching dispositions in quite a few cases. This would have been around the time that I began my tenure in the summer. And I can't be quite sure the causes, but I do have some idea, and I think it's due to SBTCs going on leave around the holidays, and also one of my highest producing individuals is on an extended medical leave that was not anticipated. So I'm hopeful that in the future quarters, we'll have a better metric here. Going to the right, I think it's important to look at the next two together. So this is overall inventory time to close. One is median and one is average. The median days to close, I think, is a good statistic for us. It shows that our intake department, which consists of 2 dedicated deputies, is highly efficient. Average days to close, it's a great improvement from the last quarter, but there's still certainly room for improvement. And what this tells me is that we do have some investigations that are older that are pulling up the average, and that's the distinction between the median days to close as opposed to average days to close. Moving to the right, it's important, I think, to consider these 2 metrics together as well. This refers to investigations only, so cases that have moved past intake. Median days spent in investigation, 234. It's an improvement from the last quarter, but certainly a place we can improve. And looking at this number here tells me that the cases that are very old in our investigation inventory are pulling up the average. But in any case, this is a place where we can improve, is our investigation processing time. Moving on to the second row, this statistic is similar to what I was just covering. Percent of cases spent in investigation for over a year, half of our cases fall into that category. So certainly where we can focus on improvement and encouraging the special deputies to be mindful of the backlog standards. The next statistic to the right is a good statistic for us. Cases closed in less than 180 days. That's 79%. That's a good number for us, and again, highlights the efficiency of the intake deputies. The next 2 statistics that you would see here on the CTC's dashboard are not in mine. We just don't have the data at this point. The reason being, the first one is crew reopens. The Rule 2201 program requests for secondary review don't go to crew because crew is internal to the State Bar in the Office of General Counsel. When we get a request for secondary review, it goes to a separate special deputy as opposed to crew. So we don't have data for this metric. And for random audit reopens, we don't have the data at this time. Projected backlog for 2023, 53 cases. So it's an improvement from 2021 where we had 65 and 2022 where we had 61. That being said, we always want to improve our backlog statistics. This is one metric that I would be interested in comparing to the other dashboard where it would be based on referral date. And that's just because there are times where cases will be underway in OCTC and the conflict does not arise until later. And in that case, it would be referred to us later when the case has aged a bit. Here we're looking at case inventory and case age. We have our metrics here about our overall case inventory. It's 95 as of the date the presentation was put together. Percent of cases greater than 6 months old, 55%. Here you can see our overall inventory over time starting in 2021. Overall inventory tends to be between roughly 50 to 100 cases, depending on our flow of referrals and how quickly we reach dispositions. At the moment, it's on the higher side. Here we have a breakdown of case inventory by age. And taking a look at the more recent quarters, kind of focusing on Q2 of 2022 and onward, we're showing a lot of what I would call younger investigations or younger cases that are less than 6 months old. I think this reflects consistent referrals from OCTC. One statistic or one thing that is reflected here that I think is positive for us is if you take a look at the cases on the right side of each grouping, those are older cases. Here, starting Q2 of last year, we are bringing down the overall inventory of those old cases over a year old. On this page, we're looking at case clearance and age at closure. The statistics here on the left are from the first page, so I won't go over them again. They're just redisplayed here. This first graphic, open and closed cases with clearance rate. There you have a comparison of matters that were closed versus open, and the dot represents the clearance rate. So like I mentioned earlier, this quarter was a great quarter for us. We reached dispositions, this darker bar being the dispositions, in far more cases than we were receiving. Going just below there, cases closed by case age. As you can see, for the most part, most of our cases that we close are the cases that are less than 6 months old. That speaks to the fact that, as is the case in OCTC, most cases are closed at the intake phase. I will point out, though, something that was positive for us, and I think it's just presented here differently. What I said before was this Q3 is where we really reached quite a few dispositions in our older cases older than 1 year. On the far right here, we have the case age at closure. The difference between the two lines is one is average and one is median. The lower line is median. I think here, seeing the departures between the average and median, like I referred to earlier, shows that we do have older investigations that are pulling the average up. I think it also highlights the efficiency of intake here, where we're getting quite a few cases reaching disposition in less than 100 days in most quarters.
Stacia, this is Ruben. Can I jump in with a question?
Sure, of course.
The number of SDTCs that you've had working on cases as these quarters elapse, has there been any significant change up or down over the time period that we represent here?
Certainly some SDTCs are more active in their SDTC work than others. I have added a few to our panel. I think 3 since I started, or 4. So we have more on our panel, but what's different between our panel and OCTC is, whereas OCTC would aim to distribute cases evenly among its full-time staff, we're in a position where the deputies are available to field cases kind of depending on their civil practice and their availability there. Does that make sense?
Yeah, it does. Thank you.
So not everyone on our panel has case assignments at any given time. Here we're looking at the breakdown between the different phases of a case. Again, these metrics here on the left are presented on the first page, so I won't go through them again. We have case count passing through each phase. This is our difference between intake and investigation. So as you can see, we have a strong intake department that's very efficient, reaching dispositions in several cases every quarter. Dozens of cases was the case here in Q3 of 2022. Below there, we have the count of cases spent in investigation, 365 days or more. So here we're focused on older investigations, and the breakdown is between the P1, the high priority, or the P3. It does seem here that in the past there have been cases that weren't assigned a priority, but that's no longer the case. The cases are required to be assigned a priority. So one thing that's positive here is we don't have any old P1s. That's a positive, but we do have those that fall into the P3 category that are over the 1-year mark. On the right, we have duration of cases at each phase. The top graph is intake, the bottom graph is investigation, and within each graph, we have median and average lines. Intake, I've said it before, very efficient. The cases are being processed efficiently through intake. Investigation is where we have room for improvement. And you can see we've got some quarters here where it's even creeping up toward the 500-day mark.
Stacia, this is
That's something we're aware of and we're working on.
Stacia,
and again, here in the CTC dashboard is where you would have your quality. We don't have the data for those, as I mentioned at the beginning of the presentation.
I'm going to jump in with a quick question, Stacia. Hold on a minute.
Hey, Stacia, regarding the investigations, you mentioned that there might be some outliers as driving up that average days in investigation. And do you have a sense of how many of those cases could be labeled as complex or requiring special, special resources or special attention?
I'm sorry, it cut out. I heard, do I have any sense of how many of those cases could be? And then I didn't hear the rest.
That could be labeled complex or have special, considerations, different complexities.
In the past, we have, in the Rule 2201 program, have not made the complex designation, and that's something that I'm looking into. I know that's something that's done in OCTC. There may be some in our inventory that spent time in OCTC and have that designation from their time in OCTC. I do know of probably one of our oldest cases that would fall into the complex category, but we haven't been making that designation in the past, and that's something that I need to look into.
Okay, you can proceed. That's it? Are there any other questions? Mr. Sowell.
Stacia, appreciate the presentation. I may have missed this, but in one of the earlier slides, you had the projected backlog for 2023, and that was 53 cases. Do you disaggregate that even further by time? So number of days backlogged, or is there some sort of further designation that's given to those cases? And then as a part of that, in another slide, you indicated that I think in this, I think it's 95 is the number of cases that are currently, I guess, maybe in the hopper right now. And I don't know if I'm doing this correctly, but I'm just wondering, of those 95 cases, are 53 of them ones that are in the backlog? You follow me?
I'm trying to understand your initial question, which I think is here. That's our projected backlog for 2023.
Right.
And what was your question regarding that?
My question was, of those, do we, can we identify those cases even further by number of days that they're backlogged? Or do you do that?
Yes, that would be possible to go and look up their exact case age by case number. Certainly, we can do that. I don't know if there's a way to present it in the dashboard, but on a case-by-case basis, yes, we can look at that.
Okay. And then if you go to the next slide, see the 95 case inventory. My question is, of those 95 cases, are 53 of them or at some point in time, 53 of them will be backlog cases? Or is that not the right way to look at this?
I think you're right there. 95 is our overall inventory. So that would be all matters within the program that have been referred from OCTC. So they may be an intake or they may be an investigation. But I think you're thinking about it correctly, that out of that, the 53 would be the 53 projected backlog. That's the metric we're looking at. So I think that's presented here is 55%.
Okay. Very good. Thank you.
Thank you. Any other questions or comments for Ms. Laguna? Thank you very much for the comprehensive presentation, Stacia.
Thank you.
Okay, it's 2:15. We've got as I mentioned, a hard start on item 703 at 2:30. Why don't we take a 10-minute break, let folks stretch their legs, and we'll get set up for that 2:30 presentation. We'll see you back here at 2:25, 2:30. Thanks. I'll call us back to order. We are recording. All right, we're going to go out of order on the agenda to item 703, the title of which is 5 Years of Reform Continues. This is a discussion of options for governance and oversight. And I've been looking forward to this presentation for quite some time since I learned that it was going to be on the agenda. I think it's going to be enlightening as to a very significant 5 years in the history of this organization, and certainly for us as trustees, setting the table for our work moving forward. This item is being presented by Executive Director Leah Wilson, Chief Trial Counsel George Cardona, General Counsel Eileen Davtian, and presenters Alex Bustamante and Amarik Singh. So without further ado, I will let Leah kick us off.
Sure, and we're going to take things a little bit out of order, as I believe the agenda item starts off with a discussion of various provisions intended to increase our oversight of conflicts issues. And the second portion of the agenda touches on discipline system oversight, and we're going to start actually with that second portion of the agenda. And as the chair indicated, really like you to view this conversation as part of a continuum of effort that really began shortly before or sometime before the separation of the state bar from the sections, our transformation into a purely regulatory agency, which of course officially took place January 1, 2018. There have been a number of initiatives that the various iterations of the board have undertaken to strengthen our capacity to be an effective regulator. And of course, one of the most important components of our organization is the discipline system. We talked earlier today, I think Trustee Tony was embracing the idea of additional legislative oversight as exercised through the budget process as one mechanism for increasing oversight over the state bar overall and its discipline system. What we're going to hear about today from our two presenters are other options for oversight, potentially oversight of the organization, but the discipline system in particular. Really ask you to think about, as you hear from Mr. Bustamante and Ms. Singh about their respective organizations, whether or not any aspects of the models that they're going to present might be appropriate for the state bar. And so what I've asked each of them to do is be prepared to give you a brief overview of their offices, particularly with respect to some key areas that I think might be transferable, investigation and audit in particular. I hope that they'll talk a little bit about the resource levels that they have access to exercise these functions, and then just answer any questions that the board might have. So I want to make sure that Ms. Singh is teed up and ready to go. Okay, there she is. Great. So we did not talk about who would go first. I don't know if either of you has a preference. No.
Mr. Bustamante, you're in the room, so we'll start with you. Welcome.
I'm in the hot seat, okay. Very nice to be here. I'm Alex Bustamante. A little bit of background to kind of put in perspective my current position. I'm a former active duty U.S. military, federal prosecutor, IG, Inspector General, and now I'm the compliance head for the University of California system. So my current role, I'm the Senior Vice President, Chief Compliance and Audit Officer for the University of California, which encompasses its 10 campuses, 6 medical centers, and 3 national labs. So to put that into perspective for you, that's about 600,000 employees, staff, faculty, students, all combined with an annual operating budget about $44 billion. So the things that probably would make sense for this conversation is we're a federated model. Even though I'm in a headquarters position, we have compliance and audit individuals embedded throughout the system. And that's just the model that UC has chosen to put in place about approximately 10 years ago. I give you an idea of the scope of my responsibilities. Really breaks down in 3 lines of service. I am the Chief Audit Officer for the system, so I will perform audits throughout the system, everything from financial to regulatory to performance and even cyber-related auditing. I will also be in charge of the investigative function throughout the system. Some of the local campuses will have responsibility for lower level investigations, certain high profile issues involving senior leadership or conflicts will be elevated immediately to my level to investigate. And I'm responsible for investigating all of the activity at the headquarters unit. If there's any issues or challenges or allegations, that'll come to my office to investigate. And those investigations usually involve what we call improper governmental activity. So simplify that, it's a serious violation of policy, law, or gross misconduct, waste, or abuse. So if it's in those buckets, it'll come to my office to examine and look at. And then the last line of service that I have is a compliance function. So on top of the auditing to ensure that our standards are being adhered to and we have the appropriate controls throughout, and the investigation to identify misconduct and treat it appropriately, we also have a training and assessment function. So we will assess where we are on any particular issue, work with the various stakeholders to do some level setting to make sure that UC is on top of the issues. And the issues range, as you can imagine with UC, everything from weapon systems of the national lab to campus safety and everything in between. So we work with the different stakeholders to make sure that there's awareness, we make sure that they have the available resources, and then we apply any expertise we have to any of the issues to make sure that we can lift up a campus and a location to get them to where they need to be. But we will routinely put out training. We will put it out in a bunch of different ways, from mandatory required training that is logged and tracked to more informational training that can run from in-person to infographics and video shorts, but it's the full complement of activities. So all those people on the campuses will report to me directly, and in many cases, the chancellors or the CEOs of the location. As far as resources, I have about 40 people in my immediate office and another 250 embedded throughout the system. And that will encompass healthcare compliance officers, chief ethics and compliance officers, locally designated officials. Those are the investigative leads in each of the campuses that make the decisions on whether to go forward on a particular item, and all of the auditors. And that's all the auditors that will do the auditing for the academic medical centers, as well as the campus positions. As far as the national labs, I have direct responsibility for one of the national labs, that's Berkeley National Lab. The other two are monitored by the Department of Energy. I'm on the audit committee for both of those. So that's a very quick snapshot. I know the time is kind of the essence here, so I didn't want to monopolize by going through everything that I have at my disposal or what I'm involved in, but I'm happy to answer questions and also happy to defer to my colleague who's going to be testifying virtually.
Thank you, Mr. Bustamante. Ms. Singh, would you like to introduce yourself, or did Leah have something that she wanted to ask specifically?
Yeah, I just wanted you to clarify. So one of the things when George and I had the opportunity to talk to you, that I think I failed to appreciate until I had a subsequent conversation with George. All of the investigators in the system, whether they be located at a campus or working directly with you in the central office, they are in a reporting chain up to you. Is that correct? You have some level of personnel oversight over them.
And the way it works in reality, though, is the campuses have their own churn. And there's cases that are specific to the campuses. They know the people, the personnel. And so a lot of the smaller level investigations are done by the campus. And although we track and we monitor and we make sure that there are no conflicts and people are appropriately handling them, we provide kind of material support, training. We make sure the investigators have best practices from anywhere from scoping an investigation to writing to implicit bias, you name it. We will make sure that everyone has got the same requisite training, and then we're constantly calibrating. But the campuses, it's really a federated model. They will be dealing with the low-level matters at their campuses, just like in the audits. They will be focusing in on the matters that are specific to their location, but certain items will be coming to my level. For example, in the audit space, if it's a regular campus-related audit, it will be performed by them. If it's something that affects the entire system, or we need to have a uniform approach to it, then my office will be in charge of handling the audit, administering it, and eventually briefing to the board. But yes, we do have some level of connection on each of the functions that I have, the 3 lines of service, including investigations. And one of the things that is important to me is I need to be able to have visibility on issues that are occurring and make some of those determinations, whether something needs to come to my level or requires additional oversight, or maybe expertise that I have that the campus may not have. So there is a tracking, and we have a system for monitoring what comes into the system and how people are investigating and whether there are conflicts or other items. And we will monitor them. So it's a really kind of cooperative relationship with the local campuses. But yes, there is a reporting line, and there is an expectation that certain minimums are going to be met as far as what comes to us and what's reported to us.
And if you were going to apply that model to our context, let's say, as we had a discussion to oversee our attorney discipline system, what would it look like to apply that model in this context?
Well, I have to admit, I don't know the ins and outs of the California Bar. Other than paying my dues and taking the training, I don't know the mechanics of how the discipline structure is set up. But if you have a federated model like ours, and you have different locations, investigators in different areas, I think it's very important to make sure that those individual locations have a allegiance to the collective. So there needs to be a reporting requirement. There needs to be other mechanisms in place to make sure that you have visibility of what's going on at those different locations, that you have the right people that are staffed, and then you have a uniform way of approaching an investigation on how to triage it. What happens if it doesn't require investigation, but some lesser activity is necessary, whether you identify something that may not be investigative worthy, but it may result in training or an audit, you need to be able to have that connection with the central headquarters function to be able to make sure that everybody's moving in the same direction, or you're going to have multiple silos and everyone's going to be doing everything a little bit differently. And what you'll have is kind of different due process at different locations, which I think, at least in the UC context, is absolutely destructive to building any kind of trust in the system and making sure that people feel that they're being fairly evaluated when they're the respondent, or that the complaints are actually being heard when they're a complainant. So I think a certain level setting is absolutely required. And that's really a significant challenge in a federated model, to make sure that you have kind of real connection with the locations and real reporting relationships, so that people realize that they may not be at a central location, but there's still an allegiance to the central location and still a process that's going to be followed.
So I have a follow-up on, I'm sorry. So is that another way of saying that you have a uniform set of standards and rules that get distributed throughout the Federation, to which everyone is held accountable?
We have a policy that governs everybody. And so, as you can imagine, the policy sets the standard for which everyone's viewed. It's the application that we have to make sure is uniform. And so we do that by training, we do that by bringing people over and ensuring that people are adhering to certain reporting standards, certain investigative best practices, that we have the appropriate controls. We also compartmentalize the investigations. So we'll have an intake function, and then the intake function will evaluate whether an investigation goes forward or not. And then that person makes the decision and hands it off to the investigator to avoid any kind of confirmation bias, where I decide that we're going to investigate this because I think it's worthy, and now I've come up with an outcome that confirms what I initially suspected. Then we have a final determining body that will be separate from those two functions, that looks at the investigation and makes the determination of whether or not it met the standard, the preponderance standard. And if not, if there's a deficiency or other additional questions, we'll kick it back down to the investigative unit to do follow-up. So we have some uniform training and standards, but we also compartmentalize items to make sure that we have different eyes at different functions, so no one controls the entire investigative process from the beginning to the end. So we can at least ensure that we have an independent assessment, good or bad, whether we have found misconduct or not. We can at least say that we've had independent people looking at this and making determinations.
Thank you. Trustee Chen had her hand up.
So with respect to the audits and compliance reviews that you do, how much of those are sort of set topics that are routinely audited, and how much of those are special topics that come up, and who proposes those topics? How do those rise to your level such that you would initiate a special review or audit?
So we perform a risk assessment process throughout the system. I team up with risk services from UC and also my counterparts with UC Legal. And so we'll have surveys that go out to all of the senior leaders throughout the system. We do it at our headquarters unit, and each of the campuses will do a separate one. We will, through that process, through talking to consultants, monitoring what's happening on that local and national level, will identify what risks UC faces in any particular location. And what we're focusing in on is items where the likelihood of something occurring is high and the risk to the university side, both of those at the same time. And we will prioritize our limited resources on those top risks. So sometimes it'll repeat year to year. For example, cybersecurity is #1 business risk that I've identified for UC, and so it will get a lot of attention from me and my cyber auditing team. But the issues will change depending on what is identified and what the regulatory landscape is, what impact we're in contacts we're having with our federal partners, what people are identifying as pain points in their operations. And it's always risk-based. We realize that we can't address all of the risks. It's not possible. So a integrated regimented risk assessment process allows us to put our resources on the highest risk items. And it also ends up being a national best practice is recognized by the Department of Justice too, in evaluating kind of corporate climate and the like. So that's how we will focus on the bulk of the items. I always reserve a certain number of hours, audit hours, for emergent issues, issues that the board identifies as being a priority for them, or things that I'm seeing that are coming up on my radar that I want to focus some of our time. And so I try not to do repetitive audits that are low risk. I'm trying to look at the very difficult issues and see if I can get the business leaders to identify the issue, recognize the issues, and then identify management corrective actions to address and fix them. And then what we will do is, for example, if we identify issues, control deficiencies, or other problems, we will then address that and tell management, these are things that you need to fix. They will need to propose something that fixes that. I will validate that as described, it appears to address the issue at hand, because I'm an independent voice and report to the board. And then after they implement that, I will then test that control or test that item to make sure it's actually operating in the way that people have indicated it would, right? So we don't have an issue that it looks great, but 2 years, 3 months, whatever it may be, we see things have gone off the rails because it's actually not working like that in reality.
So the University of California, of course, gets audited by the California State Auditor, as does the California State Bar. What role does your office play in responding to issues that the California State Auditor raises? What role does your office play?
So I'm the lead contact for the California State Auditor. And so when they come in on a particular audit, my responsibility is to make sure that the various locations provide whatever information the California State Auditor has, and to make sure that we're allowing them to perform their job and to have access necessary to identify whatever the issues are. So I'm a facilitator. I obviously try to make sure that the way that they conduct their audits and the way that they treat information is respected, and that they have access to absolutely everything, and to demonstrate that we're a good partner, and B, that we recognize that we can always improve and we can always do things better. So to try to help facilitate that relationship. But when they come in, they stand in the shoes of UC, and they can have access to absolutely everything. And my job is to get them whatever they need so that they can do the job quickly, and we can get back to kind of our operations.
So say they identify issues in their report. They've come in, they've done their audit, they've identified areas that need improvement, process issues, gaps. What then does your office do?
Well, we'll go through the exit process. We'll talk with them. We'll provide information if we think there's additional information they should consider. But if they come up with the recommendations, we will present that to the board, and we will ensure that the board has the information, the president is appropriately briefed on the information, and then they will be the ones making the determination on whether to accept or not accept the recommendations.
Mr. Stallings.
Sorry, not sure if you're prepared to go into this, but just from a cost standpoint, are there any best practices as far as how many regulatory employees you have assigned to a particular amount of employees at like a particular UC campus or a portion of UC, like any ratio that you employ?
It's an interesting question, because I've been trying to determine that as well. Because as you can imagine, at different locations, we have different resources. And so the idea is, do you identify number of personnel and say for X personnel, you're going to have, one auditor or one investigator? Do you look at budget? Do you look at the sophistication of the operations? I think there's a lot of variables, at least with regard to our shops, that make it hard to identify what the right amount is. I can always tell you when we don't have the right amount, but you're in, I think, a space where really a lot of it depends on what the leadership posture is regarding compliance, and whether you have a strategy, like how many items do you want to be looking at? How deep a dive do you want to look at some of those items? Because that's going to be broken down in audit hours, right? So if you have a very ambitious audit plan and you want to look at everything throughout your footprint, and you want to make sure that it's not at a very high level, but you're able to do some testing and go into the meat of things, you can figure out what that would cost roughly in audit hours to be able to perform that by talking to experts. And you may be able to reverse engineer things that way, but I'm not aware of a standard in which that happens. And we get peer reviewed every 5 years, part of our standards. And so we've consistently asked people, is there a national best practice regarding that formula, and have yet to be able to find one.
And then just to follow up, is there a, I guess, what is the portion of the UC budget that is spent then on your shop and on that whole regulatory space?
I have roughly a $9 million budget.
And
But that doesn't account for the campuses who bear the financial burden for their local staffs. That's just for my office, and the bulk of that involves personnel, and then my audit function is what we will do on some of the system-wide audits that we have is we co-source them, which means we have a relationship with, for example, now Deloitte, where we will team up with Deloitte to be able to do some of the specialized audits, and then we'll be able to leverage their bench when we have something that's very sophisticated that we may not have the expertise on to come in and be able to help us the function. So that $8 million is really just my immediate office. The campuses have their own outlay for their audit functions and their compliance functions, and all of the third-party vendors and resources and training that they actually use.
Great, thank you.
Any other questions for Mr. Bustamante? Seeing none. Thank you, sir.
Thank you.
Miss Singh, welcome.
All right, thank you. Good afternoon. All right, hope everyone can hear me okay. I am going to attempt to screen share and share my presentation. It's short. It's a short presentation. I can do this. All right. All right, so thank you for having me here today. I am Amarik Singh, the Inspector General, and my agency provides oversight to the California Department of Corrections and Rehabilitation, so CDCR. So we are the sole oversight agency. Our sole entity that we oversee is the Department of Corrections. Just sure this is working. All right, so briefly, our mission is to bring transparency to the prison system through monitoring, reporting, and making recommended improvements. Just a brief history about my office. We were established by statute in 1994. And since that time, we've had some expanded responsibilities, greater oversight responsibilities. We were restructured. Some of our responsibilities were removed. And then in 2019, once again, we have audit authority given back to us. So at this point, we are functioning under the current statute as in place in 2019, where we have our roles and responsibilities to provide that contemporaneous oversight over the prison system. Oh, let's see. Come on. There we go. All right. We were established by statute to be an independent governmental entity. So we are completely separate and apart from CDCR. We have no reporting structure with CDCR. We are our own agency with our own budget and report directly to the governor, in essence. We have a number of penal codes that help us with our responsibilities. Most important is the one that says that we have full access, unfettered access to anything that CDCR has, any records. We are given full access to any prison, any parole agency. We can go into any institution to look at any records and inspect any of their processes that we would like to provide oversight to. Gosh, this is going backwards, I'm sorry. So I just wanted to give you a brief overview of the services that we provide. So my agency has employee discipline monitoring. We monitor critical incidents and staff complaints, uses of force, We have an intake unit where we receive complaints from the incarcerated population or stakeholders or their family members. We're the ombudsperson for sexual abuse complaints. I'm the chair of the California Oversight Rehabilitation Board. We do medical inspections for the institutions to ensure the incarcerated population has access to medical care and they're getting quality medical care. And then we also do all of the warden vettings. In essence, once a warden is put in place by the Department of Corrections, the governor asked my office to vet that person to ensure that they are qualified to be the warden of a prison. So today I'm really just gonna focus on two of our services that we provide, and that is our discipline monitoring, our staff complaint and grievance monitoring, and basically our audits and special reviews. So discipline monitoring, which might be more in line with what this entity is looking for, is our focus is on oversight. So we oversee CDCR's Office of Internal Affairs investigations. Every time there is a request that comes in for an investigation, statewide, it all comes to one entity within CDCR, and they review every request that comes through. We have a seat at that table. So every week we are as well looking at every single request that comes statewide, and we make our recommendations to CDCR as to what we think would be the best way to handle this complaint or this request for investigation that has come forward. At that time, we also select which cases we want to monitor, which cases are open for investigation and being sent back to the individual institution for an investigation. We'll select those cases. And our monitoring criteria was basically developed as a result of litigation. The department was sued by a number of incarcerated people for federal civil rights violations. A special master was appointed by the federal court, and the special master helped dictate a lot of the important criteria that we still use today to select which types of cases we are going to monitor. Those cases include use of force, code of silence, allegations of dishonesty, any type of actions that are potentially criminal misconduct. So when I say monitor, after we've selected the case to monitor, we actually sit down with the investigator and we talk about the investigative plan, what direction the investigation is going to go. We offer our recommendations, and then we actually go into the institutions and we monitor each of the individual interviews that are conducted in connection with that investigation. We don't ask questions, we just sit on the sidelines and we listen to what's being asked. We will offer recommendations if appropriate before the conclusion of the interview. And sometimes they're followed, sometimes they're not. We'll follow that case investigation through the report process. We'll review draft reports, again, making recommendations to the investigator. And then once the case is completed, wrapped up, and sent to the hiring authority, which in most cases is the warden of a prison, we will then monitor the employee discipline process from that point. We will make our recommendations to the hiring authority as to whether or not we think allegations should be sustained or not. And if there are allegations that are sustained, if there should be any type of a penalty imposed. And if there is a penalty imposed, we also review the adverse action and the action that's going to be taken against the employee. We'll go through the state personnel board hearing process. We'll follow the case up and through any writ or appeal that's filed. So in essence, we monitor every single aspect of an investigation from the time the investigation is opened until the time it is closed, whether there were no findings or there was a penalty and the penalty was upheld. And then we take all of that information and we put it in a public report, and we report that every 6 months for my discipline monitoring unit.
Cameron,
So my
oh, sorry. I want to make sure to put a pause, and so I want it because I want to really highlight the difference between your model and Alex's model. But I'll let you finish. I thought you were moving on to another topic.
Yes, I'll finish off with my discipline monitoring, and then I'll go ahead and pause before we jump into the next unit. So just for the functionality, it's 4 teams. We are statewide. We have 3 teams that are in regional offices, Sacramento, Bakersfield, Rancho Cucamonga, We also have a headquarters team. The team is about 25 positions. That includes the attorneys and the supervisors. And then, as I said, we issue a report every 6 months. And just some numbers for nuts and bolts. For our reporting period from July 1 to June 30th, the Department of Corrections received over 2,500 requests for investigation. They approved just over 2,300, and we accepted 340 cases, or we picked up 340 cases for monitoring. I put staffing on there as a bullet point just to point out the fact that our goal is to monitor about 25% of investigations, but because we are not always fully staffed and we haven't been fully staffed, we haven't really been able to meet that mark. So obviously 340 is not quite the 25%. We try to average no more than 30 cases per attorney, but then again, once we're fully staffed, we'll be able to really make those adjustments to be able to monitor the full 25%, which we believe is sufficient to be able to give us enough information to make those meaningful recommendations to the Department of Corrections when it comes to the discipline monitoring, investigations, and the actual imposition of discipline. All right, so.
Okay, great. So if please, I want you to both correct me, because I think this is what is really interesting to me about your two models. And Alex, in your model, you similarly, both of you have oversight into all of the investigation requests that are coming in. They might be different types of investigations and for different reasons, but both of you have visibility into that entire universe of what's happening. And then Amerix, in the IG model, there's a sample that is pulled using a risk-based or some kind of criteria. And for that sample, the IG's office is actively monitoring the investigation that is being conducted by another agency, CDCR. And their active monitoring includes providing input into the investigation plan, monitoring interviews, reviewing final reports, etc. They cannot direct the activity of the CDCR investigators, but they certainly give their opinion. And if CDCR does something different than they think they should do, that will be in a report. In the UC model, you use a risk tool to determine which investigations central office is going to handle, and then you do those investigations yourself. And with respect to those investigations that are retained at the campus level, you aren't necessarily weighing in on any of these aspects, like the investigation plans, the results. You're more providing training and sort of proactive support on quality, but you're not doing anything active with those cases that are retained at the local level.
Well, yes and no. Generally, we won't get involved, but if there are areas and investigations that we think warrant a little oversight, we will be involved in the scoping of it. We'll be involved in who needs to be interviewed. We will ask for information to be reviewed with us so that we can make decision points along the investigation and influence what we believe needs to be done to ensure that the investigation is done correctly. So that doesn't happen all the time, but if there are kind of high risk or areas that we're concerned, we'll ask for kind of ongoing briefing, and we can direct them if we feel there's a conflict or some other issue. We can take that up to our level as well.
Any other distinctions that you guys, because I'm always trying to think about how would we apply this in our context. In our context, in the IG model, there would be some sample of attorney discipline cases, perhaps 300 a year, that this independent office would actually get involved in monitoring the investigation of these cases while they are underway. That would be the IG model applied to our system. Applying your model is a little bit harder because the investigators would ultimately need to report up to you, not to the chief trial counsel. It would be a completely different model. So it's a little harder for me to think about how it would apply in our context. And I don't know, George, if you want to come up, but I think to help the board in their brainstorming, it's helpful to understand how these models would actually work.
Could I ask a question? Ms. Singh, when you talk about what, can you tell us a little bit about what goes into a public report? So what sorts of things does your public report highlight that you have gleaned from your monitoring of various investigations and handling of cases?
So we have, in the penal code, it lays out exactly what the legislature would like us to report publicly. And so what it details is the nature of the investigation, the quality, the discipline that was imposed, the appropriateness of the discipline. So every single case that we monitor, it remains confidential. We don't identify the prisons or the staff member. We will publicly put on our website every month the cases that have closed in that month, which details a summary of the allegations, the findings, and the quality of both the investigation and the quality of the discipline process, including how the hiring authority handled the disciplinary process, whether they made a correct decision or not. So those are the critical areas that we highlight and we publish every month, and then we summarize it at the end of 6 months and identify any trends or any consistent issues that we saw throughout the state. And because we monitor every single prison throughout the state, so we're able to make any distinctions between, say, the southern area and the northern area, if there's inconsistencies in how the department is actually following their own policies and procedures.
And does your report then also highlight potential areas for corrective action and monitor implementation of those actions?
Yes, every report that we publish has recommendations, and we follow up with the department every 60 days, 90 days. There's a set schedule, and we ask them to send in their corrective action plans. There are oftentimes that they will follow our recommendation, or they'll do some sort of modification as to how they can best implement our recommendation. And honestly, there are some recommendations that they believe are not in their best interest and they will not follow. And it can vary depending on the type of recommendations that we make.
So can I also ask a slightly different question of Mr. Bustamante, because I feel like focusing on investigations that his office does may not necessarily be the right focus, because to me, the analog at UC is UC does have, as part of their regular operations, certain areas in which they engage in their own sort of discipline process, whether it's student misconduct hearings, whether it's faculty or personnel investigations, it's academic senate discipline determinations, on the healthcare side, medical staff privileges determinations, and those are sort of an analog where could be a fact-finding hearing, there's evidence received, a fact finder weighs in on whether the allegations are substantiated, and then a sanction is imposed. What sort of oversight or monitoring have you done of those processes, and how does that play out?
It's a great question, because there are different investigative teams for different issues at UC. So we have Title IX, and they're distinct from my office. We have some Title VII related investigations, discrimination and like, that are generally conducted by our HR teams and our system-wide HR teams. We don't get involved in the hearing process or on the discipline side. So we're purely the fact finders. So we will look in and investigate the matter, and then we will provide it to an independent person to assess our report, to determine whether or not they agree with the findings that we have, and then they will provide that to leadership. And leadership makes the determination, at least with our model, with those improper governmental activities, they'll make the determination on what punishment is appropriate in a particular circumstance. And we try not to get involved in the decision of discipline. We want to maintain a level of independence, that we are strictly looking at the facts, and we're looking on whether something is substantiated or not, and we'll make a recommendation. But at the end of the day, ultimately, we can't validate our own work. There's a separate person that will work with us that looks at our investigations, as I had indicated earlier, to determine whether or not we have met our standard, and whether there's the quality control is there, and there's no other investigative or other matters that needs to be reviewed. So in that way, we have, it's not a full hearing, but we have kind of the process that tries to find that independent that independent assessing body to determine whether or not the investigation actually is substantiated. But for the hearings for the Title IX or for student misconduct or the academic medical center or faculty misconduct, yes, you're correct. There are hearings that take place, but I'm not involved in those.
And just to follow up on that, Highland, I'm sorry, the independent person that you've just described or office, is that outside the UC system? Is it?
No, it's inside, and there's some terms of art. So for example, my office, I have a director of investigations. The director of investigations will triage anything that comes in and make a determination of whether they believe an investigation is warranted in that particular case. They will meet with UC Legal to ensure that they have weighed in to determine whether the investigation is appropriate. They will then take it to what's called locally designated official. It's an official appointed by senior leadership that will then concur with our call or say that they think things need to be expanded or no investigations warranted in that matter. Once that independent individual makes the call and says we're going forward, a charge letter is initiated. That charge letter goes through to my investigators who will then begin the process of looking at whether misconduct has occurred. When they finish the report, it's packaged up and it's presented to that same person that charged the investigation. And they are advised by what we call an investigative team, the I-group team. So there'll be HR, there will be my team, they will be UC Legal, and we will present what the investigation showed, didn't show, whether we agree with the recommendations from the investigation, and give it to that independent person to make a determination of whether they concur or don't concur, or whether they believe more investigation should occur, or whatever their concerns may be. Once they make a determination that, yes, we see that there's misconduct here, I agree with the recommendation of the report, that gets packaged up and sent to the leadership team, and then correspondence goes out to the complainant and to the respondent indicating what has been determined. But it's ultimately up to the leadership team to make a determination.
Great, thanks. Go ahead, Ivan.
So switching then to a slightly different topic that I'm aware of your office being in charge of is there are some instances where there's a big high-profile investigation that results in a report or something being publicly released about it that includes a commitment to take certain corrective actions to keep people safe in the future. Mm-hmm. My understanding is that in some instances, your office will then monitor and oversee implementation, because it can be a long process to make sure that all those items get implemented, and it's your office that makes sure those things are being done, and you report on it to the board.
Yes, that's absolutely correct. I mean, we've had situations where misconduct has been determined, and not only will there's corrective actions that have come out from litigation or from state review or other processes, and I will be in charge of ensuring that all of those corrective actions are implemented. In some cases, I'm actually appointed the monitor, not only at UC, but for court purposes, to be responsible for overseeing and ensuring that those corrective actions are actually implemented. So that does happen on several matters. There are also times where there will be issues that are identified, and instead of using the investigative team, we will use the audit team, and we will come in with our auditors who will be looking at the process deficiencies. And then if there are individual acts of misconduct, we'll spin them off to the investigators, but they'll be doing that more holistic kind of review of whether we have deficiencies in kind of the administrative sequencing, whether we have, shortcomings in the investigative process, and then they will again come up with management corrective actions.
All right, any further questions? Or Mr. Cardona, would you like to add anything to the discussion?
I don't think Mark was done.
Oh, I'm sorry.
I interrupted her.
All right. And I'll complete my presentation. Just want to highlight just two more areas that might be of interest to this entity. And that's the staff complaints monitoring. It has, the name is a bit of a misnomer, but this is the unit that actually looks at the grievances sent in by the incarcerated person. And so this is not cases that are investigations that are being requested by supervisors and wardens. These are actual grievances that are coming in from an incarcerated person who feels like they have been victimized by staff in some way. And the staff complaints monitoring in 2022, the Department of Corrections put into place brand new regulations to handle the grievances that come through by the incarcerated population. This process is actually a direct result of a report that the Inspector General's office that we issued in 2019. In 2018, we did a robust review of how the department handled grievances at one particular prison, and that was Salinas Valley State Prison. And we made some substantial recommendations, which included in essence, your system is broken and fix it. And so as a direct result of our work, the legislature has invested billions of dollars, both at the Department of Correction level and for me, in order to create this new monitoring process of grievances. And this has been set up similar to the discipline monitoring. And I wanted to highlight this because this is actually a brand new unit that both agencies are building. And so right now we are going through that building phase, and we are going through some of the growing pains in order to really figure out how to do this in the best way possible. But what we found is following that discipline monitoring has been very helpful in that all of the grievances are coming to one central location for centralized screening. They're being reviewed, and they are being then sent for an inquiry back to the prison for an investigation, or to the Office of Internal Affairs for a more formal investigation. We similarly monitor these grievances from the beginning to the end. We monitor the investigations that occur, and we monitor any discipline that is imposed on a staff member in regards to these grievances. Similarly, it's 4 teams. Well, we have teams at headquarters, centralized screening, local, and investigations. This team is attorneys, their deputy inspectors general, their analysts. We started off with 5 members. Right now we're at a little over 20, and we're slotted for 86 positions. So this is actually a team that's growing. And again, we do issue reports annually. Similar to discipline monitoring, every claim, every case that we monitor, we also publish on our website. We've just built that in. So again, we look at the same types of areas, the quality of the investigation, the quality of the discipline process, and basically did the department follow their new regulations. And just by way of some numbers, 166,000 over claims were received by the department last year. Over 20,000 were referred for an investigation or inquiry. And because we basically have had anywhere from 5 to 7 people working in this team, we only monitored 32 claims this year. So more to come, but the goal for this, just because of the large numbers of complaints, I'm not sure how many the state bar gets in relation, but we selected 10% in regards to investigations and inquiries, because we felt that would give us the significant volume where we're able to find any trends and make meaningful recommendations based on what we were seeing. So this is exactly being built similar to the discipline monitoring unit. And just to wrap this up, we also have audit and authorized special review responsibilities. And this is basically my agency is able to, at my discretion, do an audit or a specialized review of any operation, policy, or procedure for the Department of Corrections. We also can get asked by the governor's office or the legislature to engage in these audits or specialized review. And similar to the UC system, we do follow government auditing standards, using the same risk assessment, surveying our staff, CDCR staff, to find out where areas are identified as risks. And then we will do a risk assessment and select an area to audit. This function just came back to us in 2019. And last week, we actually published our first audit report, which was how the department, their interdiction efforts on keeping controlled substances out of the prisons. And we're actually working on another specialized review that we just started on implementation of SB 132 into the system, and that was a legislature request on that. This team has 11 staff members, but again, staffing issues. We currently are operating with 6 staff members. So we're not being able to really do as much as we want to, but we're in the hiring process. And just as a wrap up, any recommendations I have when building an oversight agency is keeping in mind that we make recommendations as an oversight entity. We don't direct the work of how the staff are doing it. If the staff is not doing work properly, we make the recommendations on how they can correct that those areas. Fairness and transparency in our monitoring and reporting is our critical principles when it comes to the Inspector General's office. I think having defined roles, having policies in place, and having a positive working relationship with the entity that we oversee is really what makes our office successful in our mission of bringing that transparency to CDCR. And that is it for me.
Thank you, Ms. Singh. I have a question for you, and that is, what is your primary interface with the legislature? Is it a legislative committee of either house? Is it the office? Is it this leadership of the legislature? How do you interface there?
We testify often as requested for both sides, for Senate and Assembly, for their public safety committees. I have a number of one-on-ones with members of both houses and their staff members in regards to several of these critical issues. Usually it's members from the public safety committees, but I also get requests from legislators outside of those committees. We testify often when the Department of Corrections is being called in to talk about an issue. They also like to get the Inspector General's perspective when it comes to some of their issues. The staff complaints, the incarcerated person grievance process, that was a critical area where there were a number of legislative hearings that both of us, the IG and the Secretary of CDCR were called to testify in regards to several of these issues.
And the number of complaints was, I guess, expectedly high, right? On that second set of data that you presented, whereas the number of actual investigations was, I don't know, looked like maybe 1/8 of the number of complaints. Is there any sort of criticism in the system for what might be called a backlog or unaddressed complaints?
Yes, there was a criticism. The grievance process, where there's the far larger number of complaints that come through, each prison had a backlog, and they have time limits built in and how quickly they're supposed to address these grievances, and they were missing the mark. They weren't getting those inquiries, they call them inquiries. They weren't getting those completed within the 30-day time frame. So they worked on adjusting how to really correct that. So the grievance process is a much quicker process, whereas the investigation process, that can take much longer. But obviously, majority of these complaints are coming in on correctional staff, which are peace officers. So there is that 1-year statute of limitations that we have to operate under. So investigations can take a little bit more time than the grievance process that they try to get completed now within 45 days.
Thank you for that. Any other questions for either Ms. Singh or Mr. Bustamante? Leah, anything else from you or from you, George?
No, I think you've heard what the systems are. I think there are distinct differences between the two and what their roles are and what they do. Particularly, the OIG gets involved in real time in monitoring ongoing investigations, which is a little bit different. I think what they two have in common, and correct me if I'm wrong, but is an audit function on both sides to audit, and not just kind of a general audit akin to our random audit, but more specialized audits where they identify issues based on risk as a basis for doing those audits. So I think that's another thing that you could look at in terms of oversight is rather than our current just random audit of a certain number of cases, some kind of targeted audit if there are issues of particular concern that you thought this might be an avenue for doing that.
I agree. I would say that when we hear sort of calls for more oversight of our discipline system, certainly there are models for increased oversight. I think one takeaway from today is they're not cheap. You hear about the number of staff associated with actively monitoring or investigating. In Americ's case, 300 or so cases, 500 cases. You're talking about scores of personnel. Alex's budget of $9 million just for the central staff. Now, of course, the UC system is much bigger, but I think real oversight isn't cheap. That's one of the takeaways that I have. But a model for active oversight could include something like independent monitoring of our discipline investigations as they are underway. That would be very different than anything we have in place today. But certainly we see that there is a model like that out there. As George indicates, there are other aspects, I think, or takeaways from both of these offices that we could consider implementing more quickly and without new resources. And that really is thinking through how we are using our external auditor that we are already paying for. Last cycle, the state auditor recommended that we increase our number of external auditors from 1 to 3. We've budgeted in 2, not 3. But those are resources already allocated, already planned. We are not using a risk-based approach to develop the audit plan. The board has not been involved in setting the scope of those audits. So those are changes that could happen sooner rather than later, and where we could draw lessons learned from these other entities.
Thank you. Good points. Okay. Thank you both very much for your time and your expertise. We appreciate you being here.
Thank you.
Thank you. Have a great day.
Thank you, you too. Okay, there are other aspects to this agenda item. I think conflicts of interest is next.
Yes, thank you, Chair. As you can see in the materials that were provided to you and also posted publicly on the website, staff is proposing a number of what we call conflicts of interest enhancements that are unrelated to the 2201 program, but they're more focused on sort of public agency related conflict of interest regulations. I would, I guess, categorize them in 3 different efforts. One is around the conflict of interest code and Form 700 reporting requirements. You will see in the materials that we're proposing to review and update the conflict of interest code that applies to our Board of Trustees. We're also proposing to take a closer look at the conflict of interest code that applies to our designated employees within the State Bar workforce to ensure that their reporting requirements are aligned and to make sure we cover all of the employees that should be filing Form 700s. As part of those efforts, we're also going to be rolling out the sharing of the conflict of interest code and having folks review and certify receipts and understanding. Alongside with the improvements on the conflict of interest code, we're also looking into training opportunities, obviously. The Board of Trustees already receives conflict of interest training through an e-module. We'll be just kind of reviewing our records and recommending that those Board of Trustees that have not taken that conflict of interest training in the last year, that they take it within the next few months. So those of you who may not have received that training will send out a notice. We are also looking into developing a more enhanced program for both the trustees as well as the employees within the State Bar. We currently don't have a program for the State Bar employees that focuses on these areas of conflicts and ethics considerations. Some of the models we're looking at includes what's commonly known as AB 1234 ethics training that covers a number of ethical principle and considerations that we as public officials or employees of a public corporation should take into account in making decisions. So the timeline and some of the detailed Activities are outlined in the report. There's no action that is being requested from the board today. As we develop these materials, we'll bring it to you for your approval. In the meantime, if you have any questions or if you have any other suggestions, we welcome those.
Thank you. Any questions for the general counsel? Mr. Tony, yes.
Thank you, Chair Duran. When it comes to conflict of interest trainings for the board, which is what I'm most concerned about, I am very glad you're doing a review. I'm not particularly impressed by the materials in those trainings, and I'm particularly unhappy about the E module because it presumes that conflict of interest is strictly an individual issue. Conflict of interest implies the whole body. It's not just at the trustees. So what I would strongly recommend, as you develop this, we're not taking action today, but as you develop it, I would like to recommend that trustees are required to do once a year, real-time conflicts of interest training. We do it together. It can be on Zoom, doesn't have to be in person, okay? And we get to ask questions. With an E module, you can't ask any questions. It's an E module. There's nothing to answer. Conflict of interest is complex. It's situational. It's not one size fits all. The difference between material conflict of interest and perceived conflict of interest is very important. And so I just think that we would be better served as a body to require, because I'll be honest, I don't know, but I don't have, if it's like you check the box that somebody has turned on an E module, you have any idea how engaged they were in it or whether they looked at the whole thing, okay? In person, at least you can see visually that everybody is present from start to finish. So that's my main comment. I did review this, and those are the comments I wanted to share.
Thank you.
Thank you, Trustee Tony. Trustee Shelby.
Just to Trustee Tony's point, in our Oversight and Accountability Reforms Committee, the name of in the ad hoc committee on oversight and accountability reforms, we've actually had that conversation in relation to, no, but I think it's something that I have raised and we've talked about it in our last discussion, and I think you're absolutely right. Annual conflicts of interest trainings, and I've shared my personal experience of doing ethics and compliance trainings led by, ethicists, and everyone is sitting around a table for an hour or engaged where people can ask questions and you can provide examples because things shift from year to year. So I think that's a great point.
And I think the fact that this item is on our agenda today is further evidence of evolution here in the agency along those lines. So thank you to all of you who have put your time and energy into putting this in front of us, and will continue to do so.
And I actually wanted to end on that note. I know we had our first conversation around, as a established body, around accountability reforms and oversight. And I really do, and I don't think I do this enough, but I really want to say thank you to Aline and to Leah, because it was a robust conversation. And I think one of the takeaways from that discussion collectively was that we need to parse things out. Everything can't be done immediately, and there are certain actions that will transpire in the very near future that will govern some of the work that will be done. But it is quite the undertaking, and appreciative of the focus that staff has placed on that. So thank you.
Thank you, Trustee Shelby, and all part and parcel of our service on this board, right? There's always a lot of things competing for our attention and energy. But certainly at the base of it all should be ethical service. So thank you. What is next on this item? There's one more thing, I believe.
No, I don't think
That's
on
it?
this item.
Okay.
I'm ready for the ad hoc commission, I believe.
All right. move on to, going back up in the agenda to item 60-3.
Chair,
Yeah.
may I request a short break? Before, this is going to be a big agenda topic.
Sure, why don't we break for 5 minutes?
Thank you.
See you back here in 5 minutes, folks.
We are now recording.
We're all the way live. Item 60.3 is a discussion and approval of the Ad Hoc Commission on the Discipline System Report and Recommendations. Ms.
Good
Chavez,
afternoon.
welcome back.
Okay, good afternoon, everyone. I'm going to share my slides. We can just get right into it. The purpose of this agenda item is for you all to have a discussion and to consider approving the Ad Hoc Commission's discipline system, to receive their final report and to review their final recommendations. But before we get there, I'm going to do a little review of where things stand as of today. Starting as a reminder, on the far left here in September, this board received the Commission's report. And at that time, this board issued those 9 recommendations out for public comment. The public comment period occurred during the months of September through November. And on December 5th, the entire commission met to review all public comments received. And the purpose of that meeting was to review those public comments and to consider whether or not they would consider changing any of their previously adopted recommendations or adopt new ones. At that time, they also updated their report. So today, staff is asking that the board receive the updated final report that is an attachment A to this agenda, to your agenda item, to consider the commission's recommendation, to also consider new recommendations that came out of public comment, and then also consider staff recommendation amendments to commission recommendations, and I'll be going through those. And then finally, we have one additional staff recommendation for you all to consider. And also, we also ask that the board direct staff to update you on the progress of any recommendations you adopt today in September later this year. So before we start talking about the recommendations, I just want to give a little brief overview of the public comments that we received during that 60-day public comment period. So it ended on November 28th, and we received a total of 78 responses. The majority of those responses were from attorneys, 54 were from attorneys. And when respondents were presented with those 9 recommendations, they were asked to essentially give their opinion on them, kind of like a vote. And they were also offered the opportunity to provide a written narrative for each of those recommendations. And so they were asked to say, do they agree with the recommendation, but only if modified? They straightforward agreed with the proposed recommendation, or they disagreed with the proposed recommendation. And we provided a report on all public comments received, and that's in Appendix J of the Commission's final report. Again, that report is listed as an attachment to this agenda item. When you go through that report, you're going to be able to see all the written narrative comments received. And at that, you will also see their names. If people are allowed to give comments anonymously, but they can give their names. They can say whether they're speaking on behalf of an organization. And they can also submit attachments in support of their written comments. And all of that is included in the report that summarizes public comments, again, in Appendix J of the Commission's final report. So as you know, the Commission adopted 9 recommendations, and those were put out for public comment. And they're listed here. And the blue, let me draw attention just a few big picture findings here. The first is that the recommendation with regarding eliminating disciplinary sanction, that's the recommendation that received the highest share of commenters that said that they disagreed with the proposed recommendation. 21% said that they disagreed. Down in the middle, you see 2 items that actually we split out the recommendation that have to do with recommending timelines for removal of discipline history from a website and expunging the discipline record. We broke those out into 2 different recommendations because those are actually 2 different business processes, and we want to give the public the opportunity to weigh in on each one respectively. And even though the majority of all the recommendations received the vote of agree with proposed recommendation, those are the blue bars in the middle, those 2 recommendations actually received the smallest share of that agreement. So as you can see, 61% and 64% respectively. Instead, those 2 recommendations actually received the highest share where people said they agree with this recommendation, but only if modified. And this is where you see a lot of public comment on really illuminating why they chose that. And here they're gave all sorts of recommendations and ideas for what should be modified. And again, you can see that in that final report. And then down at the bottom, recommendation 9 with regards to implement the appointed counsel program. This is for the purpose of improving attorney representation as they face disciplinary proceedings. Actually received the highest share of votes for straightforward agreement with the proposed recommendation. Okay, so now we're going to move into the commission's recommendations. And as I noted, before I get started, they adopted 9 recommendations. As the agenda item notes, staff is recommending some amendments to them. Staff recommends that this board adopts 5 of them, but for 4 of them, we recommend amending them in some way. And so what I'm going to do first is go through the ones that staff recommends that you adopt, and then we'll turn to the ones that we recommend a slight modification. So first, staff recommends 2 of the item with regards to the recommendation with regards to discipline costs. And the recommendation was for the State Bar to reevaluate the discipline cost model with the focus on reducing costs. So staff recommends that you adopt this one. Recommendation number 3 has to do with the early neutral evaluation, which is to seek a statutory amendment to extend the deadline for the transmittal of a criminal conviction matters to allow for an ENEC. Staff also recommends that the board adopt the 2 recommendations that have to do with moral turpitude. And the first one has to do with to direct staff to work with stakeholders to study all revisions with regards to how we can create a pre-transmittal meeting similar to ENEC. And this recommendation number 7 has to do with working with stakeholders to understand and clarify all rules with regards to referral to the ADP, with the Alternative Discipline Program. Another recommendation staff recommends is the one with regards to progressive discipline, which is to analyze and consider modifying these standards to prevent greater exercise of judicial discretion. So now we're going to turn to the items where we recommend a modification. So the ad hoc commission recommended with regards to discipline costs to seek a statutory amendment to eliminate disciplinary sanctions. And here staff recommends to the board to direct staff to study this further. And the reason we do so is because our reading of Business and Professional Code 6086.13 appears to have permissive language, and that language is right here. We've emphasized the word may, which is that the State Bar, any order imposing suspension or disbarment of a licensee of the State Bar accepting a resignation may include an order that the licensee pay a monetary sanction. And so there is a State Bar rule that tells us how to implement this statute. And we're directing, we'd ask the board to direct staff to really just explore this further, whether or not, given what appears to be a discretionary statutory language, and we will consider, of course, the concerns expressed by the commission. The commission is concerned that having disciplinary sanctions is, just patently unfair, and so we will do that. And next, with regards to recommendation number 4, which with regards to the early neutral evaluation, that recommendation reads to direct staff to work with stakeholders to propose revisions to all applicable rules to promote the use of the ENEC as a mechanism for arriving at pre-filing settlements of State Bar disciplinary proceedings. We recommend that the board adopts this recommendation. However, to delete the word pre-filing, as noted in an earlier presentation, we have our proposal for new case processing standards suggests change in the ENEC to a post-filing activity. The LAO says to also study this further. So by removing the word pre-filing from this recommendation, it's going to allow us to have more flexibility when we explore this topic. So that's staff recommendation for modifying this recommendation. Now with regards to recommendation 5, which is to adopt timelines for the removal of attorney discipline history from the attorney profile and expungement of discipline history, staff recommends that, this board directs staff to develop alternative timelines to those that are listed here, which are adopted by the ad hoc commission, and to define expungement. The reason for this recommendation is that staff anticipate public protection concerns. The proposed timelines by the Ad hoc Commission are inconsistent with the Medical Board of California, which only allows for the public removal of public approvals from their websites. And the timelines here are actually longer than those of the California Nursing Board. We also need to update an analysis of all 50 states' practices for removal of discipline history from the website. The commission relied on an analysis that was conducted in 2016. So we would like to update that analysis. And also we really need to define what it would mean to expunge discipline records. This report has shares the commission's ideas of what that means, but it really needs further study, further delineation, so the board can make a decision about this recommendation. So that's our recommendation here, is for you to direct staff to develop alternative timelines and to define expungement. And then finally, with regards to recommendation number 9, so to implement a state bar appointed counsel program based on the hourly rate structure similar to the 67-point appointed counsel program. We recommend that the board does adopt this recommendation. However, to adopt it and consider funding it at the mid-year budget review. There's a significant general fund deficit projected for this year. And what staff would do is develop an implementation plan for this program, and in the interim, and then we would be ready to launch it once funding is approved at the mid-year budget review. Okay, so those are the 9 recommendations that the Ad hoc Commission adopted, and staff's response to 4 of them, or staff's alternative recommendations to 4 of them. Now I'm going to move into a set of recommendations that staff developed in response to public comment. So when we reviewed all those public comments, again, the idea was to consider new recommendations or modifications to the Ad hoc Commission's recommendations. And so at that December 5th meeting, we shared staff's suggestions for recommendations that made sense in light of the previous deliberations, et cetera. And it was decided that staff would develop them further and present them here for you all to consider. So they're not commission adopted recommendations. So here's where we landed with those. So there was, and of the public comments that drove these recommendations, but potential new recommendations are listed in the agenda items, and they're listed in italics so you can read them. But basically, we heard from 2 different people who talked about how they recommend or advocated for the state bar to also develop new timelines for attorneys who resign with charges pending and those who resign without charges pending. So the idea is that those 2 discipline acts, those 2 outcomes are listed on attorney profiles. And so they're recommending the development of those timelines for those 2 scenarios. And so we talked about and had, again, an initial conversation for these 2 items at the Ad hoc Commission meeting in December. And so where we landed with this as staff is that just to substitute those 2 recommendations with this one below, which is for you to direct staff to develop a proposal that addresses the website posting of discipline history for attorneys who resign with or without charges pending. And then at that time in the proposal that we would explore, we're also going to explore the implication of future reinstatement, because that can happen for attorneys who do resign without charges pending, and then submit this proposal to the board for approval. So that's our recommendation there. We also heard from some public commenter who talked about the fact that the administrative suspension is on the public website indefinitely. And so recommendation here is to develop for the board to direct staff to develop a timeline and procedure for removing administrative inactive enrollments from the attorney profiles on the State Bar website and submit them to the board for approval. So remember, the Ad hoc Commission, they adopted timelines to the removal of discipline. This has to do with adopting a timeline, developing timelines and procedures for the removal of administrative inactive enrollments. What are those? Those are matters where someone goes inactive because they were either in non-compliance with the MCLE requirements, they didn't pay their licensing fees, or they were not compliant with the fingerprinting requirement. And so if you were to go to someone's web page and any of those things happen to them, it would indicate that they were inactive or not eligible to practice law in California. And again, something like that is online indefinitely unless that person petitions on a one-time basis for the removal of administrative matters from their attorney profile page. So staff recommends that the board adopts this recommendation. Another recommendation that came to surface during our reading of public comment is the idea that one recommendation is to configure the State Bar website so that internet browsers could not index the attorney profile pages. Again, this speaks to the broader issue of attorneys being concerned that their discipline history is online, it follows them for years, and someone suggested, why doesn't the State Bar consider this? So we actually did some research on this, and we got in touch with the Department of Consumer Affairs. They develop and manage the medical board's kind of website, the part of the website that allows the public to look up doctors. And we learned that they do not configure its website to prevent indexing. And so we recommend that this board do not adopt this recommendation, because preventing indexing would ultimately raise concerns about public protection and transparency, as well as the fact that the DCA does not do that for the medical board's similar doctor lookup function. Okay, so those are the
if I may just interrupt here, just to ask for those in the public who may be watching and listening, or those of us on the board not so familiar with the interwebs, what does it mean by indexing?
I think what it means is that even though, there's a function, right? So if you go to our State Bar website and you type in someone's name, that's when their attorney profile page comes. I believe what it means is that make it so even though if something like that is embedded in our website, a search engine can pick it up.
Okay.
I think that's what it means.
That sounds right. I see some nodding heads. Thank you. That's helpful.
Okay, so those are the recommendations that flowed from the public comment. Okay, so now we're going to turn to one last recommendation developed by staff. So this recommendation has to do with criminal convictions that are ultimately subject to expungement. So in particular, it reads like this: direct staff to explore the removal of criminal convictions and discipline from the profile pages where the sole underlying basis for discipline was a criminal conviction that was ultimately expunged pursuant to Penal Code Section 1203.6, and submit the proposal to the board for approval. Now, staff believe that this recommendation is aligned with the Commission's interest in really allowing attorneys to move past previously imposed discipline. And so here are the options we would explore. So one option is that attorneys, criminal conviction is expunged, and then we would say explore an expedited removal of the notice of criminal conviction and the disciplines that's on their website. That's on the State Bar website. Or we can propose some timelines that are similar to the discipline that would similar to be other timelines that would be adopted for previously imposed discipline. So those are two examples that we would pursue, but ultimately it's along the same lines of developing timelines and how to deal with material that's on the website. And so this has to do with removal of criminal conviction transmittals and discipline that the result was a criminal conviction that was ultimately expunged under Penal Code Section 1203.4. And so staff recommends to the board that you adopt this recommendation. Okay, so the way this would go moving forward is, again, here we are. You would consider those recommendations. If you accept our recommendation to adopt the attorney profile, the attorney appointed counsel recommendation with the understanding that you're going to review funding mid-year, that's what happened. And then staff would come back to the board in September to give you an update of any proposals based on recommendations that you adopt today. Okay, thank you.
Thank you, Ms. Chavez. Comprehensive report that really represents the culmination of months and months and many, probably at this point, hundreds of hours of work from all of the volunteers on the ad hoc commission themselves, Trustee Stallings, you and other folks in your office, and a lot of public comment that the board has received as part of today's packet, including late-breaking public comment from the California Legislative Black Caucus. We thank them for taking the time to to contact us with their input and their concerns, which we value very much. With that introduction, let me open it up to the trustees if there are questions for Ms. Chavez. And if not questions, then certainly your thoughts on the recommendations before us. Trustee Tony, thank you.
Lisa, could you explain, just what I'm having the hardest time figuring out is what is the connection between the findings of the Farkas report and these recommendations?
So some of them are relate to the Farkas report and some of them do not. So the one that's most evident right off the top of my head is the one with regard to the attorney representation program. The biggest finding that came out of the Farkas report was that if you want to understand, one of the biggest findings is the racial ethnic gap in discipline is explained by many factors, one of which lack of representation for Black men who are facing discipline proceedings. So that really addresses that issue. But really so many of the recommendations have if it's not a direct link, it's like a really indirect link. I know so many of the commission members, when they talked about, say, for example, progressive discipline, their opinion, it was really driven by their concern to remedy what they saw was disparate impact in discipline over the years. That's one example, like the progressive discipline one. Again, timelines removed from the website. Again, the kind of like the common thread there is, if Black men have been disproportionately disciplined, but impacted by discipline, they're the ones whose attorney, they have more discipline online. Therefore, they would benefit most from having it removed on a timely basis.
Thank you. May I ask a couple more of these type of just questions? Thank you. How much of the, just in your own assessment, what do you see as the kind of the portion of the disparate treatment in terms of disparate discipline, particularly falling upon Black male attorneys, that's attributable to things like lack of representation, and how much is attributable to implicit bias that might be addressed through some of the diversity, equity, inclusion trainings for the OCTC staff, for the judges that preside over these cases. I'm trying to get at how accurately these measures correspond with addressing the issue that I think we're all trying to get at.
Hey, Lisa, if I may.
Okay, sure, go ahead, Brandon.
Yeah. So I think, Trustee Tony, your questions relate more to a discussion that we had, really, I think back in 2018, 2019, where we received the report from Professor Robertson, who we had tasked with coming up with recommendations on how to address any disparate impact on the African American male population. And so out of that, out of us working with Professor Robertson, he came up with several different proposals. So when we talk about reportable bank actions, that was a significant area that we looked to first study and then see if there were any reforms that could be implemented. As Ms. Chavez mentioned, one of the recommendations was to develop kind of like a public defender system to provide representation. When you've heard presentations about the beefing up of our self-help material from the State Bar Court, that was one of the recommendations. So there were many things that we saw that we could implement immediately, and that's what we did, as far as working with lawyers to see if they could provide representation for reduced fees. So some of those things did not have a huge impact dollar-wise. But what would have an incredible impact on the budget would be a public defender type system. So that was one of the items that got sent over to the ad hoc commission. But in large part, Professor Robertson's recommendations have been implemented and are continuing to be studied. And so, for instance, when we go back and look at the metrics and the revised metrics that we're now considering, those relate to some of those concerns that Professor Robertson raised. So I don't know if that provides any clarity as far as the scope.
I appreciate that, Trustee Stallings. I'll reserve my further comments for when we get to discussion.
But I think I want to answer it even more head on, that Professor Farkas himself did look at the basis. Why do we see the racial disparities in outcomes that exist? And he identified the factors: disparate number of complaints. Black male attorneys, I believe, and Lisa can correct me, receiving, I think it's 10 to 1 in number of complaints versus their white male counterparts. So it's disparate number of complaints. The majority of those complaints being reportable action, bank matters. It's all the client trust accounting stuff. Then it's this issue of lack of representation, least likely to be represented in the state bar discipline system. So we actually specifically looked at the why, and all of the explanation was able to be statistically derived from the various factors that Professor Farkas identified. And then Professor Robertson generated his recommendations from that. And so I think we do feel very confident that implicit bias or explicit bias is not the reason for the racial disparities that we see in the state bar discipline system, at least not as statistically determined. And I don't know, Lisa, if you want to add to my understanding of the Farkas analysis.
Right. Let me just add a little bit about the number of complaints, that explains a lot of the variance. That means that it explains a lot of the racial gap that we saw. And Professor Robertson recommended that the state bar shield from view closed complaints. He had a series of recommendations how the state bar could deal with closed complaints, because the idea was he was concerned that is potentially where bias could come in. And that what I mean by closed complaint is a complaint that was closed without discipline. So if the numbers show empirically that African American men have higher numbers of complaints that were closed without discipline, his concern was that could potentially be bias. Another complaint comes in, and it's a form of bias. So he had recommended either expunging all previously closed complaints, or I forget what the other recommendation is, but this board adopted a policy for at least in the interim, to archive complaints that were closed without discipline once after 5 years had passed. And so our plan is to actually study the impact of this policy next year. So we wanted to let enough, I believe that was passed in 2020. I believe we implemented that policy in fall of that year. The plan is to study its impact. And if it works the way it should, if we potentially holding all other things constant, there would be fewer, say, African-American men cases are being sent to investigation. Again, holding everything else constant. This is where a very rigorous, tightly controlled study of using all data available will be important.
Thank you for the question and the several answers. I appreciate that. Any other questions from the trustees? Trustee Sewell, please.
So in looking at it looks like that we did, and Lisa, thank you for the presentation. It looks like we did a really robust job of trying to solicit public comment to the commission report, to the report. Well, by my calculations, so we got 78 respondents, 54 of them were attorneys. And so that is somewhere in the neighborhood of sort of 70% of the respondents were attorneys. And I guess part of me is just sort of wondering, here's kind of what I'm feeling. I'm sort of feeling that some of the recommendations that have been generated and the responses to those recommendations seem to me to fall into a couple categories. Please help me if I'm off base on this, just let me know. But it seems like it is some effort around leniency in terms of, lightening the load, so to speak, in terms of disciplinary actions. And then the other category is somehow lifting some of the length of some of the public exposure that you've been disciplined. Am I off base in terms of thinking that way?
I'm not, yeah, I don't know, Lisa, if you want to give your opinion.
The commission was charged with evaluating the effectiveness and the fairness of the system. So I think what you're saying is that you see a lot of recommendations that are addressing fairness. And I think that's true, because that was their charge. And so I believe that the commission, they interpreted fairness in that way. It was probably a very broad way of thinking about fairness. For example, the timeline, that's like, it's unfair for, people's profiles to be up for, perpetuity. They heard public comment for people say that this, these charged 20 years later, there's, someone Googled their name, et cetera. They look at, and there's this thing from 20 years ago. So that's what I would say to that. Leah?
I don't know if you want to say.
Yeah, I'm sorry, Arnie, just to respond to what Lisa just said, and I was involved with the ad hoc commission at the outset. And I think that there's a distinction and a meaningful difference between fairness, as she's described it, and as the commission members discuss at length, and leniency, as I think, I don't know whether that's which I'm not sure how you meant it, but leniency almost carries a negative connotation in the context of a disciplinary process, right? It's not that that the intention was to go softer, for lack of a better word, on certain populations, but to ensure that those populations were treated fairly in the context of the system as a whole, as opposed to just being lenient on them at carte blanche, if that makes sense.
Yeah. So I follow you, and I was trying to look for a word. Lenient is what came to mind. Fairness, I follow as well. I think part of me wonders, as a non-lawyer, and I can't remember how many non-lawyers were a part of the sort of the ad hoc committee. I can maybe completely off base in terms of what I'm getting ready to postulate, but whether or not that they would, things would have followed the same way.
So I'll just offer my recollections and observations, and then maybe Brandon can supplement with the more recent work of the commission. There was a critical mass, for lack of a better word, of non-lawyer members. I can think of maybe 4 or 5 who were pretty regularly active with contributions, and certainly not shy to express their opinions from the perspective of a non-lawyer, very much similar to the way that our fellow trustees here do in this room, which was valued in that context. Brandon, you may have another observation.
I think that we had robust discussion, and it was really, there were, I guess for lack of a better term, different camps who had more votes for different proposals, and so some of the proposals were very narrowly divided in whether or not to make recommendations. The individuals who were public members, I'm just going down the roster here. We had Janet King, public member, Jerry Larkin, National Organization of Bar Council, had Department of Consumer Affairs, Ms. Schneider, Martin Winfield, Affinity Bar Association, and then Gary Farwell, Affinity Bar Association. I can't recall specifically if they were lawyers. Some of them were. So I think that the defense bar, had a voice regarding maybe a little bit more leniency or equity. We had great participation from the Office of Chief Trial Counsel, who were speaking at it from a position of, what they see the rules accomplishing and how they can best protect the public through either maintaining the status quo or going a different direction than the recommendation. So I think we generated a lot of really good discussion. Some of the votes, like I said, were extremely close, and that's why some of these proposals are coming to the board really ultimately for our review, and to see if we want to make a policy change to reflect some of the issues that we've seen come up in the California legislature. If we want to align ourselves with some of the criminal reforms that have been passed recently. And so I think you're really touching on something that the commission really wrestled with, which is, can you have an effective system, and can you also have an equitable system, and how do you maintain that balance? So I think, we wrestled with that, and I don't know if there's a perfect answer to that conundrum.
No, I appreciate the responses to my questions. Clearly, I want the discipline system to be fair and to be equitable. And at least for me at first blush, and looking back at the recommendations again, for some reason today it just sort of struck me that it seemed like there might be some, I don't know, it seemed like the scales tipped a little bit in I did use the word leniency. I want us to be fair and equitable. I don't necessarily want us to be lenient.
Thank you, Arnie. Points well taken. And I will correct myself. It looks like there were 3 active members. Maybe for some reason at the outset there were more than 3 public members, but in the roster that I'm just looking at, I see 3 designated public members. So, Mr. Knoll, your hand is up. You're still on mute, sir. There you go.
Is that better?
Yes.
Okay. Thank you, Mr. Chair. I don't really, I mean, as a person, I don't need any more data to know that the rules of discipline, how the bar is going to run from the beginning, was decided by powerful white men. I believe the answer, kind of an answer to Arnie, that what happens today is that there are articles in the paper, there's this, that, and the other about unfairness. And what happens is people who are concerned with trying to bring equity to a situation where African American lawyers feel that this system is not for them. It doesn't, they're outside in a world of their own. And not every African American lawyer, but my brother-in-law and my wife rose to great heights as African American lawyers and never felt that this institution was something that they could grasp onto, and that would be helpful to them. That the rules never took into consideration where they come from and all of that. What I understand is that suddenly now you have a commission who is hell-bent on providing equity. And equity means you go sometimes the extra mile, maybe towards leniency, because you've got to bring people that have been treated unfairly for decades. You've got to bring them up to at least an equitable situation with their white counterparts in a disciplinary system. I think the ideas that the commission has come up with may be a little lenient, but I think I know why, and I think we ought to try it. We've tried something else, and it's been proven to be stereotypically racist from the moment it started to be implemented to now. So it may be that some of these recommendations go too far, but I don't care. I want to try it. I want to see that if we're really concerned about equity, diversity, and ultimately real equality, then you do the things like attorney representation. You do the things like helping them with, a mentor on client trust accounts. Because the biggest problem for solo practitioners all across the land is they don't have an infrastructure that takes care of those things. I mean, they have to do that in addition to being a lawyer and going to court and all that. It's just, for me, I think that as our esteemed vice chair pointed out, they had a lot of discussion and they got to be close to, a couple of recommendations, and some didn't make it and some did. I got to give them a hand because I think it's time to try something radically different than what we've been doing for the last 100 years. And this sounds that way to me. And we assess it, if it's not working, if things that we change it. But being an agency that's nimble, that's quick, that's able to adjust when they do a study and find out, whoa, maybe this thing went a little too far, let's bring it back. I just think we ought to try it. And that's it. I'm sorry to go on, but I'm passionate about this.
No need to apologize, Greg. I think you've reminded me that as a policymaking body and board, that's part of our job is to go on and on about things that are important to us and for which we've been given charge. And certainly we've got tools here in front of us to direct policy as the board sees fit. So thank you for the reminder. Any other questions for Lisa, Brandon, or Leah, anyone else? Seeing none, any discussion or a motion? Mr. Tony.
Thank you. First, I want to really appreciate Trustee Noel's comments. I really appreciate where they're coming from, and particularly with his particular history as a movement attorney for several decades. I respect him and I respect his positions very deeply. I do want to express some thoughts and concerns here. So let's go back to the credibility of the ad hoc commission. The actual numbers, according to what's posted on the website, is 23 attorneys and 3 public members. That's what's on the website. I presume it's accurate, okay? Because it lists each person who is a lawyer, and that is what the count has. So this board is much closer. At full complement, 6 public members, 7 attorney members. And that kind of feels that it's a little bit more balanced. And so that's one, that's a factor to the way I look at this and think of this. I appreciate, I really appreciate Vice Chair Stallings reminding us that the board has and the staff approved and the staff has implemented already a number of measures that are very targeted and designed to address the discipline disparities. And I wonder to myself, and I'm sure that we don't quite have all the data, but gosh, I wish I had the data for how effective they've been, okay? Have we seen the needle move? Are we still stuck? As Trustee Knoll is concerned, are we still stuck at the same place of the report? Now, in my imagination, and maybe this is just my imagination, I would like to think that the measures that have been taken are starting to move the needle. So that's another thing. I worry, like Trustee Sowell, that some of the recommendations kind of quack like opportunism, okay? That, yes, some of them may deal with the, and might have some impact, perhaps, on black male attorney discipline, but some of them just look at ways to go easy on attorney discipline. That's what it looks like to me. And, I read very carefully, and I do appreciate the letter submitted by the State Legislative Black Caucus. And I appreciate the assertions that the adoption of these recommendations will make a contribution to increased equity. What I fail to see is to connect the dots. It's easy to say that it's going to do this. I'm having a hard time seeing the actual case being made other than assertions. And so I'm going to throw something out, which is that I would like to have an open mind, and I would like the opportunity to look at this, think about this more, and to provide staff and others to go a little deeper in trying to figure out where are we actually at today. The Farkas report was at least 4 years ago. That was a point of time. Where are we at today? And, which of these recommendations really have the strongest correlation? And I'm thinking that we could look at paring down what we have and being much more focused. And, this issue, and maybe, again, I'm just making stuff up, but, I'm very, very, with all the cuts that we have been making in our budget, I'm very loath to adopt new programs with significant expense. I just am. And, I wish there was a way that we could compare. What are other models and possibilities for increased representation? I understand the value of representation in a court of law, okay? Are there pro bono models that are potentially out there? Are there attorneys? Are there firms who are interested in protecting the integrity, who have enough interest in protecting the integrity of the profession that they will say, you know what, to protect the integrity of the, we'll put some resources into this because we want to see more diversity in this field. Maybe contributing some pro bono time to this representation pool will get them a little mark, a little plus on this, certification thing we're talking about, DEI certification thing, okay? Part of what I'd really like to encourage is that if there is not a burning, urgent deadline that requires us to make a decision today, that we consider returning to this at a later board meeting, March or June, with a little bit more information, a little bit more thought, a little bit more analysis, because this is the kind of thing that I think would be nice as a body to kind of come as close to consensus as we can. And I'm certainly not there today. If the vote is held today, I'm voting no on every recommendation today. I'd like an opportunity to give more thought to this and have a little bit more thought in this whole process.
Thank you, Trustee Tony. Leah, please.
Yeah, I just want to say one thing. When I returned to the bar in July of 2021, the ad hoc commission had been formed. And in looking at the charge of the commission, it was a little surprising because it is and was much broader than simply coming up with recommendations to address the FARCUS report. So I think it's important to recognize the charge that the then board adopted for this commission. It was to develop a comprehensive set of reforms dealing with the discipline system's fairness and effectiveness. So to now impose a condition on the recommendations that they all tie directly back to the FARCUS report is a bit unfair to the integrity of the commission, because that is not what they were tasked with doing. So I want to make that first point. The second is, if you look at these recommendations specifically, I think they afford you the opportunity, many of them, to do precisely what you're asking to do. The first one, reevaluate the current discipline cost model. It's not asking the board to decide today to eliminate all discipline costs. It's not proposing a new cost model. It's simply saying, yes, we're going to reevaluate it, because the data in the report does show that we are an outlier in the country in terms of the level of discipline costs that are imposed on respondents. Certainly, we're an outlier when you compare us to the criminal justice system, which has essentially eliminated all fees. So it's saying reevaluate. The second one, seek a statutory amendment. That may be one where you say, let's vote no on this one because we're not prepared to move forward with any statutory amendment just yet. The next one, direct staff to work with stakeholders to study. That's all you're doing. You're not coming up with any actual recommendations about this particular issue, moral turpitude. Next one, on the alternative discipline studies program, direct staff to study what are the applicable rules. On progressive discipline, analyze and consider modifying. Next, we come to discipline cost, where staff has a different recommendation from the commission that, to your point, will just require us to study the issue, not take action, and so on and so on. So I would say, instead of having a blanket approach to all of the recommendations, if you really look at them, many of them afford precisely what you're asking for: more time, more analysis. And I think the proposal is for staff to come back in September with an update. So not March, not July, but September. Not before then would you be asked to take action on any of these. And the ones that are directing more immediate action, perhaps those are the ones that the board considers postponing. So That's what I wanted to suggest as a way of proceeding.
Thank you for that, Leah. Trustee Tony, do you have a response to any of that? Does that alter what you're?
I don't understand the urgency of approving anything today.
Fair enough. Any other input? Mr. Stallings?
I would just say, I don't know if this is urgency, but the work of the commission is reflected in this report, and the recommendations are for staff to continue to push this ball forward. And so we may not have the answer today, but what I think approving this agenda item does is it continues that work. It brings the work of the commission to a hopeful end, and gives staff some direction and ways to use our valuable resources to continue to look at the potential impact. And maybe at the end of the day, staff comes back and says that it would not do what we think it might do. So I think that approving this gives freedom to staff to continue to look at this very important topic, and shows that we as a board are committed to following reforms, potential reforms, maybe suggested reforms that in the end don't pan out. But it shows that we are committed to this and are going to continue that work.
I've got Trustee Shelby and then Trustee Chen.
I wasn't going to chime in, but I don't think this question was answered, and so now I'm curious. Is there any sense of urgency? Because I hear what Trustee Tony is saying, just from and I appreciate, I think so vividly back to my very first board meeting, and this commission was coming together. And I think back to, one of my very first votes was that I noticed there were no African-American male attorneys on this commission. And you also graciously held off on that, and we made sure that there was the addition. I believe we ended up with 3 on the committee, the way that it's constituted. And so I guess my question, and I certainly appreciate that the committee has spent very focused time on this, but if we're trying to be thoughtful, is there an impact to the decision-making timeframe if we were to push this off until March? I guess I haven't heard anybody respond to that yet.
Also a fair enough point, and I'll give Ms. Chavez and or Ms. Wilson the opportunity to respond if they care to.
I'll start, Lisa, and then maybe you can jump in. I don't think by March we will be able to do the type of analysis that Mr. Tony is suggesting would need to be done to sort of justify the recommendations, meaning looking at updated sort of FARCUS type data that is slated to be done in 2024, 5 years after the study was completed. So, but in terms of the significance of the time period between now and March, I would say no. If any of these were going to be included in this year's legislative package, for example, March would not be too late. The only item related to funding, we had suggested postponing the funding decision anyway to the mid-year. I would want to be really clear on what the board's expectations were about what was going to happen between now and March, because as I said, the vast majority of these recommendations are really to further study an issue and to bring back additional information in September. So I don't know what you would be thinking we would bring forward between now and March that might help the board make a decision. And I don't know, Lisa, if you have any other thoughts.
No, I agree with you.
Before we go to Highland, I'm sorry, just any response on either Shelby or Tony's part on that? Just I think what I hear Leah asking for is, okay, if we're going to put this off for 2 months, can we as a board give some further direction as to what it is we're going to expect to see or want to see in that 2-month time period? And maybe it's something we can think about as we're continuing the discussion, and I'll let Trustee Chen go.
Oh, I was just going to say, it might be helpful to actually look at the language of the resolution, because I think they really do make clear that what the resolution is really just directing State Bar staff to go back and do some more analysis, go back and come up with a proposal. Right? I mean, to me, it's just sort of saying, it's us saying, hey, start on the process looking into these things and developing a proposal and come back with that, which we can vote up or down on. But it is more study and more work. And I think that really comes through in the way the resolution is drafted in a way that I don't think is that apparent from the slides.
So to that end, then, if we could please have the resolution up on the screen, and as it's coming up, the observation that I have is this is the culmination, as I said at the beginning, the culmination of the ad hoc commission's work. These are their recommendations. Some of the recommendations staff hasn't 100% agreed with, and so they've offered us some changes to those. I'm not sure what the right word is, curious or disappointed or surprised that there aren't members of the ad hoc commission here offering their input. Certainly we see the report and we appreciate their work. I would be interested in hearing their thoughts on continuing this item, because as it stands from where I sit, they've finished their work, they've given it to us, the staff has massaged it a little bit, and I feel like they deserve some movement on that work, absent some other, imperative to forestall it. But that's for the board to consider. As Hylin has requested, the resolution's up on the screen. Brandon, go ahead.
Mr. Chair, if I could just add one thing. So if you look at the agenda item, towards the end, there are several minority opinions that were drafted by members of the ad hoc commission. So we certainly wanted members who did not agree with the ultimate vote to be able to express their viewpoints. So I think you do get a diversity of the members' viewpoints, even if it wasn't reflected in a majority vote. It is a 200-page report, so a lot to weed through, I understand.
And just a follow-up question there, and I'm not sure if it's for you, Brandon, or for Lisa, but any of those minority opinions relate to the timing of moving forward at this time? I mean, my recollection is they were sort of substantive disagreements with, some of the recommendations.
Yeah,
Yes, that's true.
Yep. Yeah, nothing specific as to timing.
Okay. So we've got the first one pretty easy. We received the report, which again, I think we can do that today no matter what. And then we've got a direction to staff to reevaluate the cost model, which we have. I feel like that was a part of the discussion at the budget committee meeting this morning for some reason. I'm not sure why that echoes to me there, but the point there being decision on whether or not to take something to trial if you're a respondent will sometimes depend on whether you have money to do it or not, and how does that further the interests of equity and fairness in our system. We've got an assessment of the need for a statutory amendment to eliminate disciplinary sanctions. And is that the one where I recall we're an outlier? California's an outlier with imposing sanctions? Was it the fact that we do it, or the amount at all?
The amount of our disciplinary costs and the fact that we impose sanctions at all.
Okay. So those are monetary sanctions in addition to probation or disbarment or suspension. Okay. Should we take these one at a time, or should I continue to read them? It's getting late in the afternoon. I don't want to lose folks.
Mr. Chair, what I would do is I'll make the motion to adopt, or to adopt all of the resolutions as stated, and then I think we vote it down yes or no. I think if there's an appetite to pass all of them on to staff, then see if that survives a second and then a vote.
Okay, so I hear a motion from Vice Chair Stallings to adopt the resolution as presented, which does include staff modifications to the ad hoc commission's original recommendations as laid out in Ms. Chavez's very able staff report. Is there a second to that motion?
I'll second that.
So I heard a second from Broughton in the room, but thank you, Greg.
Okay.
Let's debate that. Or let's take a vote if we've debated it. Mr. Tony, please.
I move to postpone this item until March.
So there is a parliamentary play at work there, Madam General Counsel. That motion to postpone, I believe, takes precedence under Rosenberg's Rules of Order, but this will be the first time we put it to the test. And I think it's a motion to continue, not to postpone, but who's, you know.
I would take the correction.
It does.
I'll second.
Okay, so I'm gonna wait for Aline to make sure I'm not making a parliamentary mistake here.
Well, I think we have to decide whether or not this is a substitute motion or amended motion.
So the motion to continue should be a substitute motion. It's not an amendment. It's basically saying we're not gonna vote on that first amendment. So the motion on the floor is to continue this item until our March meeting. It's been seconded. I don't think that's a debatable motion. Arnie, go ahead.
I thought it was debatable. Or at least
It is debatable?
I don't know.
If the motion is passed, requires discussion of the agenda item to be halted and the agenda item to be placed on hold. The motion can contain a specific time in which the item can come back to the body. Could be done. I move we table this item until our regular meeting in October, etc.
Okay.
Or, yeah.
Okay, which is a debatable motion. The motion by Mr. Tony, seconded by Ms. Shelby, is to continue this to March meeting. Debate on that item. Ms. Chen, please.
So I have a question. And I think this is a question that Leah asked. What is it that we want to see between now and March if we're delaying till March?
What I would like to see is something that connects the Farkas report with these recommendations, could be the Roberts. The case has not been made. I'm willing to consider the case. There are a bunch of assertions here. The case hasn't been made. That's my thing. I am willing to consider a case if someone is willing to make it. It has not been made. Not in this document, not in any of the documents we have received has the case been made. I want to see the case.
Well, I frankly don't understand what that means. And to go along with Leah's point, I don't know that that was the charge of the commission.
Anyone else?
This is Arnie. Two things come to mind for me. One is there was reference made to recommendations that have already begun to be implemented, and trying to get a little bit more information about what some of those recommendations are, and sort of the state of play in terms of their implementation. The second thing that, and so that'd be something I'd like to see. The second thing that, question that I have is, it seems to be asserted that if we postpone this, the work of the commission has to continue. And it would seem to me that the work of the commission has been completed. Isn't that correct? And so there's no additional work for the commission to do. It's now in our hands, right?
That's correct.
Or do we have to accept that first resolve clause in order for that to happen?
Well, I can be corrected if I'm wrong, but I believe that the work of the commission is done. They've submitted their report, and